filing was done without the consent of the court, without the permission of the court, and certainly without the consent of the applicant.
You heard that, Chef?
So I raise a formal objection to the affidavit on the following grounds.
Oh, just a minute, Mr. Jeremy. The fifth name, Mr. Khan, you filed an affidavit?
I'm sorry, it's Mr. Jagview and Mr. Jagview. I have it as Mr. Jagview, the 15th. It's the second supplemental affidavit of Dr. Bara Jagview. And he, on my list, which I admit may not be correct, is named as the fifth name.
We know who it is. It's, as I said, the rubric is going to have to change based on. So, an affidavit was filed on behalf of Mr. Jagdew and Mr. Ali.
Well, it says, it declares itself to be filed on behalf of Dr. Bara Jagdew, and there's no reference to Mr. Ali in it. So I would have to say no.
I will deal with this the same way I'm dealing with Mr. Boston's affidavit that I'm now learning has been filed. So I will review those affidavits and determine whether they will be permitted. So let's just get on to the arguments. Thank you.
Okay. Your Honor, I address you first on the question of jurisdiction.
Mr. Jeremy, your time starts now at 2:20.
I'm obliged, Your Honor. Now, this court has held in Holiday, and the Court of Appeal has held in Moore at paragraph 42 of Holiday, 34 of Moore, that it is equally clear from Kumar, Norton, and Hamilton that where an election officer has not followed the process as outlined in the relevant statutory provision, such failure is open to judicial review. At Holiday 42, Your Honor said this: I am therefore cognizant of the restrictions that would require the approach to the court by way of election petition. However, there can clearly be cases where the court's supervisory jurisdiction can be invoked to ensure the correct and smooth operation or progress of the election proceeding or processes. And then you said these words, Your Honor: a court cannot shirk its duty in this regard and shelter behind a contention that an election petition should be filed when the case clearly does not so warrant. Now, in Holiday, Your Honor would know that the alleged failures on the part of the returning officer to comply with the provisions of Section 84 of the Representation of the People Act, insofar as they spoke to the mechanisms set out therein in respect of the tabulation of votes, there were breaches, alleged breaches. Now, here we see that this is not an election petition case, because no election petition can resolve the question relating to the impasse which now exists between the chief elections officer and the chair of GECOM. To argue otherwise would be nonsensical, because you do not get an election petition without resolving this dispute. This is more than this, Your Honor, is a case which is more worthy of intervention than Holiday, a case for the exercise of the supervisory jurisdiction of the court. We do not challenge the validity of the election. The challenge is squarely to the proper processes to be employed. Now, the question which is raised in Molina Friend's submission is, okay, well, you challenge the validity of a law, and they point to section 22 of the election law as being the impugned law. And of course, they point to the statements of Bollers, CJ in Petrie and Sikoma, which are well known. But, Your Honor, in the Chief Justice Bollers was speaking of challenges to the validity of a law, the effect of which would have been to declare the entire election void. So there would have been no election. An injunction was sought to restrain the CEO from holding any election. And similarly, in Sikoma Singh, the challenge was to pending elections laws, and an injunction again was sought to prevent the holding of the election. That was the basis of challenge. And that is the context in which the Chief Justice, learned Chief Justice, said that you test the unconstitutionality of those laws in an election petition. That is not the case at bar. In the case at bar, we are four square within Holiday. The court has, as Your Honor said in Holiday, a narrow jurisdiction to ensure that the proper processes are followed. Now that applied to Mingo, Mr. Mingo, in Holiday. We say it applies in this case to the dispute between the chair and the CEO with greater force. Now, Your Honor, Mr. Justice, the learned Chief Justice Bollers premised his decision at the time on the following words. In Sikoma Singh, he contrasted what was then Article 92 of the Constitution and Article 71 of the Constitution. Article 92, as Your Honor would know, is now 133. Article 71 is now 163. Article 92 provided for the general rule of the High Court in civil matters, and the route was all the way from dispute, Court of Appeal to the Privy Council. Article 71, which dealt with election petition, ended at the Court of Appeal. And in Petrie, at 304, and again, I'm not reading the pages, I'm obeying your injunction. The Chief Justice said that constitutional, there was a tension between those two articles, which still exist in the Constitution. And he said that constitutional challenges go to the Privy Council. And to permit such a challenge in respect of a law pertaining to an election, which would otherwise remain in the Court of Appeal, might lead to confusion. That is what he said, and I'll just give you the reference. I would not read it, but this is Petrie at page 304, letter G of the West Indian Report, Your Honor. Now, the CCJ says at Eslin Davis in paragraph 35 that as the final court of appeal of Guyana, this court has a responsibility to ensure that there is adherence to the Constitution. And they seem to, not seem to, they have interpreted the constitutional provisions in Guyana in such a way that elections issues, which they now indisputably go all the way to the apex court, they have said that they've implied that there is no possibility of the conflict of the type which the Chief Justice envisaged in Petrie. So that I say that Petrie and Sikoma thing can be distinguished, and I rely on Holiday for the purposes of determining the jurisdiction of the court. So we seek the court's determination of the question that in exercise of its supervisory jurisdiction, as to which of the positions articulated by the constitutional officers is correct. That is what we see. That's a matter that can be dealt with in an election petition. It is a matter that must be dealt with by way of judicial review to smoothen the process of the election within the language of Your Honor in the Holiday case. Now, my learned friends point to paragraphs 106 and 107 of Ulita Moore. Now, I'm not going to read the paragraphs, and they say that the court in Ulita Moore was suggested that a challenge to Section 22 should be brought by way of an election petition. Well, I have two things to say on that, my lady. One, I repeat myself, I say that the decision in Holiday covers exactly what is in dispute here. And secondly, I say that at the time when the court made those statements, there was no Order 60 in being. So in the language of paragraph 107, that's the last sentence I'll read. This is from the joint decision. The court said there was no sufficient evidential basis for such a determination at this point. And the determination to which they adverted was the question whether GECOM has utilized or utilizes its powers under Section 22 unlawfully. Now, Your Honor, I turn now to the question of so that is all that I propose to say on the question of jurisdiction. I have traveled this road in my submissions and in my submissions in reply.
But can I just ask you this question on this point? I note what you just said about the Court of Appeal decision in Moore, but what effect would that have on this court as a court of first instance, that where the Court of Appeals seems to have made a very clear statement that Section 22 should fall for consideration in an election petition. How is this court to address that situation? Because remember, I'll be bound by the Court of Appeal decision.
Yes. Your Honor, the question, the dispute in Ulita Moore was frontally, and in the end it failed. Those words are to be treated as obiter.
Which word, sorry?
The okay, so they say, and it begins at 106. I didn't want to read both sections to you, but if I could just read it.
Just go to the paragraph. Don't worry to read it. I have the
106 and 107. Your Honor, we say obiter, that the main issue in the case was.
Yes, but Mr. Jeremy, it is headed fourth issue, constitutionality of Section 22. There's a specific heading in the judgment, 1, 2. I think it's earlier in the judgment, they mentioned that Dr. Francis Alexis raised this issue, and it was there was an objection by Mr. Mendez that he was raising a new issue that had not been raised before either the High Court or the full court. But the Court of Appeal nevertheless clearly decided that they wanted to address it and have a very specific heading. So when you say it's obiter, I'm trying to understand how.
Your Honor, in the case, the Attorney General was not joined. So we did not get off the ground in terms of a direct constitutional challenge to Section 22. There are these words, but there is that sentence which I read at the outset, which says that there is no sufficient evidential basis for such a determination at this point. And my submission is that the fact that the Attorney General was not joined, the fact that he was not there to defend the law, that this issue was, there are pronouncements, and those pronouncements are problematic, but they do not bind this court. They form part of the obiter, Your Honor. Those are my submissions on it.
Very well, proceed.
So,
we have
Your Honor,
12 minutes, so when I have a couple questions to ask, well. Yes, go ahead.
okay, I turn now to the question of Section 22. Now, the Attorney General is here, and he's here precisely because Mullen Friends objected to the fact that he was not a party to the proceedings, and therefore the law could not have properly been challenged. He's here to defend the law, and he is a party to these proceedings. We say that, and we make a frontal attack on Section 22. We say that it is unconstitutional for the reasons set out in our submissions. I'm not going to repeat those submissions, again following the injunction of Your Honor. But in particular, we see that it violates the separation of powers principle. Parliamentary delegate, it's not possible for Parliament to delegate, but rather to purport to delegate lawmaking functions to an executive body without more. And we say that Section 22, even if it is modified in the manner suggested by my learned friend, Mr. Mendez, added respondent 5, 6, 7, 8, or whatever. I just read the part, the way that he suggests the
Yes,
law.
I have his submissions, yes.
So,
Even if modified as he's suggesting.
yeah, so I just want, I need to read those, that, unfortunately, Your Honor, I actually need to read from it. He said that if you, this is the one I read.
Which paragraph are you alluding to?
Just give me 1 second, Your Honor. So that Mr. Mendez would assist me. So he says that paragraph 30 of his submissions, that the law could be modified as follows: to delete the words include, I'm not going to read section 22 to you.
Yes, go ahead.
But as a matter of fact, I need to read it. If any difficulty arises in connection with the applicability of this Act, the Representation of the People Act, or the National Registration Act, or any relevant subsidiary legislation, the Commission shall, by order, make any provision, and these are the words that he suggests should come out, including the amendment of the said legislation. And then we go on, that appears to the Commission to be necessary. So it will be that appears to the Commission to be necessary or expedient for removing the difficulty. Full stop. And it would, so he says we should strike, and any such order may modify any of the said legislation in respect of any particular matter or occasion, so far as may appear to the Commission to be necessary or expedient for removing the difficulty. Now that deals with the argument which cannot realistically pass the straight face test. You must smile at it, that the Commission can amend the law. Obviously it cannot. So what he has done is to take out the triggers to the exercise of the Commission's powers. But the difficulty with that, Your Honor, is that if there are no triggers, the section is at large. It gives the Commission power if any difficulty arises to, by order, make any provision that appears to the Commission to be necessary or expedient for removing the difficulty. That is works, right? So that is Parliament. That is a power that vests in a Parliament. It cannot vest in a subsidiary lawmaking body. And for that, Your Honor, I want you to turn just overleaf to paragraph 27, in which Mr. Mendez correctly identifies the principle, because you can't get, when a difficulty in the English law, seek an American authority. And that's in 27. So we have a series of American authorities, but they don't help us. If you look at the end of paragraph 27, which is just overleaf, page 7 of 18, Mr. Mendez cites Whitman versus American Tracking Association. Now, in that case, the late Justice Scalia said this: in the history of the court, we have found the requisite intelligible principle lacking in only 2 statutes, one of which provided literally no guidance for the exercise of a discretion. And the other, well, that is not relevant for present purposes. But I would just, my submission, Your Honor, is that this is quote by Mr. Mendez's admirable reference to Whitman versus American Trucking, in that the GECOM with section 22 as modified by him is left with no guidance, in the words of the late Justice Scalia. Let me be intellectually honest. Literally, no guidance for the exercise of its discretion. There are no triggers for the exercise of the discretion. Say again? So that we see that section 22 is bad, and it is like Humpty Dumpty. So that all the king's horses, all the king's men cannot put section 22 together again. Now, what is even worse is that Parliament is dead. And the legislation at 22.2 provides that the regulation, if there must be oversight. It's subject to negative resolution. So no guidance for the exercise of discretion, and the fact that Parliament is dead. Now, I turn quickly to Order 60. I know that I have 6 minutes, Your Honor. Quite apart from the unconstitutionality of Section 22, which gives rise to the purported order, and I say purported order for a reason. And here I turn briefly from Mr. Mendez to who has joined the party as an added respondent, to the second respondent, who is a named party, the chairman of GECOM. Now, the chairman of GECOM says at page 5 to 6 of the submissions are not identified in paragraphs. So just at pages 5 to 6. She says that the power to resolve controversies is recognized by the court in Ulita Moore at paragraph 109. That is true. But, my lady, in Eslin David, the CCJ held at paragraph 41 that the jurisdiction that is conferred by section 163, this is paragraphs 41 and paragraphs 47 and paragraphs 52. They held that the jurisdiction conferred by 163, Article 163, is capable of addressing the allegations of irregularities complained by Mr. Harman and alluded to by the CEO. The chairperson of GECOM and so on was therefore perfectly entitled and right to take the position that these allegations, if pursued, should be addressed by an election petition filed in the High Court as contemplated by 163. And I'll ask you to read 47 and 52 as well. So that our submission is that Order 60 does not, in fact, in the language of the CCJ, because the CCJ makes it plain. My learned friend says it does not. But this is a paragraph that I have to read, because It's ordinary English. And if it does not mean what it...
Just a minute, I mean, which paragraph is ordinary English as your time is about to elapse?
Paragraph 52, Your Honor. It says, with respect, the notion that Order 60 could either impact interpretation of the Constitution or create a new election regime at variance with the plain words of the Constitution is constitutionally unacceptable. So the point is that Order 60 does not create a new election regime, and that...
Mr. Jeremy, I'm subject to your views. I got the impression that the CCJ was there speaking to the decision of Justice Reynolds, where His Honor stated that the Order 60 in effect created a new regime that spoke to two sets of elections.
Yeah, that's precisely so. That's precisely so, Your Honor. And they set him right. They said, no, it does not do that. That the order does not create a new election regime. And that the principle is that the Constitution prevails when there is inconsistency, which is, I suppose in hindsight, Miss David was wrong in making that contention. Now, Your Honor, the plain words of Section 96 of the RPA suggest that the Chief Elections Officer shall, after calculating the total number of valid votes of electors which have been cast for each list, do certain things. That information is to be furnished by returning officers under Section 84 sub 11. The affidavit of Mr. Lowenfield, which is evident before this court at paragraph 8, contains a summary of changes of ballots made. Those changes were not done by the presiding officers in the presence of appointed company agents under the RPA. Section 83 tells us how votes are to be counted. 84.2 is relevant. Tells us when, knows, and how a request for a recount should be made. And my lady, if there is no other law but the Constitution, if Order 60 is not in place, then the constitutional provisions must be followed, and those provisions do not contemplate a result other than that which has been there's no power under the RPA to allow the chair to set us. There's no power under the RPA to allow the chairman of GECOM to set aside declarations made under the RPA. That's at paragraph 41 of the CCJ. Paragraph 41 of the CCJ in S.N. David. That jurisdiction is for an election court alone. So if it's for an election court alone, then the chairman of GECOM cannot do what an election court is empowered to do.
Good. Thank you very much, Mr. Jeremy.
Thank you. Yeah.
There are just a couple quick questions. I know that you've exhausted your time, but I didn't see any mention in your written submissions of Article 162, so which speaks to the powers of GECOM and from which GECOM derives its powers. Do you consider that Article 162 permits the enactment of Section 22? Did you get my question?
The question was, does 162 allow for
the enactment of Section 22?
Your Honor,
And by extension, Order 60.
Okay. 162 must be read in conjunction with the CCJ decision at paragraph 41, which says that Article 163 is the relevant article for treating with these matters. So the answer to the question is no. In my submission.
Right. Now, in relation to the Moore decision, the Court of Appeal decision in Moore, the Court of Appeal permitted the recount to proceed in the face of the objections by the applicant that the recount was unconstitutional. And then the court at paragraphs 85 and 88 of the decision say that the decision to hold a recount were matters within the domain of GECOM, which were shielded or are shielded by section 141 of the Representation of the People's Act. So what do you have to say to that? That the Court of Appeal allowed the recount to proceed despite the arguments that it was unconstitutional?
Well, Your Honor, I say this with the greatest respect. It is one thing for the recount to proceed and to provide fodder for either party to mount an election petition. It is quite another thing to breach the express terms of the Constitution, which say that a declaration cannot be set aside by the chair of GECOM, and GECOM had no. They did not say that was a power which resided in GECOM.
Sorry, I'm missing you there.
I'm sorry, Your Honor. It is one thing for a recount to proceed,
yes,
and to provide perhaps fodder for the contesting parties to provide succor, to provide comfort, to provide grounds for a future election petition. But the point is that nothing in that order which gave birth to the recount can supersede the provisions, the express provisions of the Constitution with respect to declarations, and nothing in that order can take away the provision, the clear words in section 163, which, as you know, begins, subject to the provisions of this article, the High Court shall have exclusive jurisdiction to determine any question, and it goes on. So that they could not set aside declarations which had already been made. And even the process for a recount is governed, as I've said, by the provisions of the Representation of the People's Act. And that order, as the CCJ has said, could not change the provisions of the RPA. And even if, as amended by Mr. Mendes, still cannot affect the primary legislation or the Constitution.
So what do you say to the Court of Appeal's decision and holdings at paragraphs 85, 88, and 89 in Moore, that it was within the remit or the power of GECOM as part of its management of the elections to hold a recount? And the court then went on to say that any challenge to a decision to hold a recount would be for an election petition. So how am I to treat with that as a first instance court?
Your Honor, there has to be drawn, as I'm trying to explain, a distinction between the recount and the setting aside of declarations. So that you can have a recount for, the first recount was supposed, and this was the issue in Unita More. The first recount was to be a CARICOM recount. And the court said, CARICOM has no business in this. This is a matter for the people of Guyana. So, Your Honor, unless I can be of any further assistance, the declarations are to be set aside by the elections court. And that is set out in the Constitution. It cannot be that it is not even the order does not even seek to set aside the declarations. At first, the original order just said that the declarations were in abeyance. It is the chairperson who now seeks to set aside the declarations. And that clearly has to be wrong.
And just one final question. Do you consider that the CCJ decision, the application and the decision, the application before and the CCJ decision in David, was it premised on Order 60 being valid?
The CCJ decision in David?
Whether it was premised on Order 60 being valid?
No, it was not an issue that was raised in the case, but the court expressed in response to submissions from those for the applicants. The court expressed the view that the order could not do certain things. That is paragraph 51. Just the last sentence. 52, sorry, my eyes. With respect, the notion that Order 60 could either impact the interpretation of the Constitution or create a new election regime at variance with the plain words of the Constitution is constitutionally unacceptable. That does not require any passing of words. It does not require any interpretation. It is lucidly clear. And we accept it. I don't know why my learned friends seek to interpret that which is plain and clear.
So then the applicant is not relying on that part of her affidavit that is saying that the CCJ decision invalidated Order 60.
Say again?
Whether the applicant is still relying on that part of the CCJ decision in which she's claiming that the CCJ invalidated Order 60.
Your Honor,
48 to 51 and 54 of her affidavit speak to that issue.
yes, yes. Your Honor, that is the effect of the order. Can I just refer, Your Honor, quickly to I know that I'm in excess time, but Your Honor did say that questions would allow me a couple extra seconds. If you look at 37 of the CCJ decision, paragraph 37, under the electoral system, and this is, they are talking here about the presidential candidate. They say the presidential candidate on the list for which more votes have been.
Please don't read it. I know what 37 says.
Okay. So they say are determined on the sole basis of votes counted and information furnished by returning officers under the Representation of the People Act. That's it. That's what the CCJ said, Your Honor. That's the last sentence in 37. If that does not invalidate 60, then my name is.
But then you have to go to can we look at 39 and 40? Paragraphs 38, 39, and 40 of the judgment.
Yes, and that relates to the counting of the votes. And it says the intention was to provide an open, transparent, and accountable recount of all votes. Then it says somewhere about assuaging the. Oh yes, in the next line, this is critical. It says the purpose was to assuage the contestation among the various parties, determine a final credible count, remove certain difficulties or fill gaps. That's 38. 39 describes how the process was to be conducted.
My understanding of your answer is that they were just recounting how the votes would be counted to assuage the contestations, but not to validate Order 60.
That's for an election petition, Your Honor. And there's nothing in the CCJ decision which says otherwise.
Okay, thank you.
I'm obliged. Those are the submissions for the applicant.
Yes, Ms. Kite Thomas.
Grateful, Your Honor. Your Honor, we respectfully rely on our written submissions. We have asked this court to dismiss this application on two main grounds. Those two grounds, Your Honor, one, the first point is on the jurisdiction of the court. Apart from the fact, Your Honor, that the issues which have been raised before Your Honor in this application, all of those issues, Your Honor, can be properly dealt with, ventilated, and ruled on, and the appropriate reliefs can be made by virtue of an election petition. That is our first ground. I will not bore Your Honor with repeating what we have said in our submissions in relation to this. We rely, Your Honor, on the Apex Court decision in the most recent case, Ali and David, and Jagbio and David. We rely on that because the court made it clear, very clear, that Article 163 is best suited for these types of disputes. The second point we wish to make, Your Honor, is that, or I would say, Your Honor, respectfully, all of these issues at different points of the electoral process, these issues have been ventilated, they have been raised in different matters. Your Honor, I wish to remind the court of Yulita Moore. Your Honor, just before the recount could have started with the CARICOM team, Yulita Moore brought an application. And in that application, Your Honor, Yulita Moore raised all of the issues which this present applicant has now raised before the court. The Court of Appeal in Guyana, the full court, and then the Court of Appeal in Guyana made certain specific findings in Yulita Moore's matter that respectfully, Your Honor, my friend, the applicant, cannot, the applicant and her lawyers cannot run from, cannot hide from. Because, Your Honor, I've pointed to court in my submissions to many of the concluding paragraphs in Yulita Moore's matter. The main one, Your Honor, that I wish the court to look at, Your Honor has already said that you don't wish us reading anything. But the main one, Your Honor, I wish the court to look at is the fact that there is a specific ruling by the Court of Appeal that the court finds that they agree with the submission that the legality of Section 22 is a matter to be frontally examined by the court at the full hearing. In Pitri and Sikumar Singh, the High Court declined to examine the constitutionality of election-related legislation during the election period, allocating, Your Honor, such questions to an election petition. The court said that such a determination would be disruptive of the election process. And the court then, Your Honor, relied on Chaitan and the Attorney General and another.
Which paragraph is that of the decision that you're reading from?
This is on pages 26 to 28 of the judgment. Paragraph 106, Your Honor. Paragraph 106. The court made a specific finding. This very issue, Your Honor, my friends, have now raised before this court again. When the Court of Appeal has already pronounced on it. Secondly, there is no appeal. There was no appeal from Yulita Moore to the CCJ. And as a consequence, Your Honor, the hierarchy of courts dictate that your court is bound by the majority decision of the Court of Appeal. I therefore ask, Your Honor, why we are here again, it's a rhetorical question, with Section 22. When there is a specific ruling that Section 22 can be best, the constitutionality of Section 22 can be best addressed during an election petition. And Your Honor, I find that that is the basis of most of the arguments proffered by Senior Jeremy. Those are the constitutionality of Section 22 is the platform upon which he bases all of his arguments. And Your Honor, that section has already been ruled upon, or the methodology to challenge the section has already been ruled upon by the Court of Appeal. And as I indicated, Your Honor, there has been absolutely no appeal from that decision. The second issue that we wish to address this afternoon, Your Honor, is the validity, as we have put it in our submission, in relation to Order 60. Much has been said, Your Honor, about the pronouncement in Eslin David's matter by our apex court. Your Honor, I first wish to ask this court, and I know this is a mature senior court, the entire judgment has to be read as a whole, to pick out or cherry pick certain parts, to misconstrue and base submissions on, Your Honor. I don't believe that this should be permitted. Your Honor, at paragraph 15 of the CCJ judgment, reference there is made to the decision of the Court of Appeal and the specific findings made by Justice Reynolds that Order 60 created a new election regime. Your Honor, it was in response to that the court made certain specific findings, that it was trite law, in fact it was elementary, the court said, that an order, subsidiary legislation, could not amend the Constitution. The court went further to say that GECOM nor the Court of Appeal could trample on the exclusive jurisdiction of the High Court. to hear these matters. Your Honor, those observations were in direct response to the decision by the Court of Appeal to read Order 60 in a particular way as amending the Constitution. Your Honor, Article 8 of the Constitution also speaks to that. What Article 8 says, Your Honor, is that in any event, even if a subsidiary legislation or another piece of legislation comes into conflict with the Constitution, it will be void to the extent of its inconsistency. Not void ab initio, but void to the extent of its inconsistency. And Your Honor, it is this time honored principle which the Apex Court was simply endorsing. I wish to make a further point, Your Honor. GECOM at no stage intended or set out to usurp, trample, trespass, or somehow take upon itself the clear provisions of Article 163 of the Constitution. That was never the intention of Order 60. Order 60, the purpose, the aim of Order 60 was simply to produce a final credible count of the votes of the March 2020 elections. How was that to be done? That was to be done in a clear, transparent manner with all stakeholders present, with live streaming. Your Honor, a reading of David's judgment in the Apex Court shows clearly that Order 60 was endorsed by our highest court. The court references the procedure outlined in Order 60. And why that was necessary? That was necessary, Your Honor, because there were difficulties, there were controversies which visited the electoral process. And what the law says must happen. The very Constitution that my dear friend is relying on, 162.1 states clearly what GECOM must do when these issues arise. And it is out of that, Your Honor, that Section 22, therefore, becomes relevant. So GECOM, all GECOM did, Your Honor, was allow, or by virtue of Order 60, allow a credible recount of the votes to be done. GECOM did not invalidate any vote. GECOM doesn't have the capacity to do so. That is why we have the clear, exclusive jurisdiction of the High Court, Your Honor, to deal with those issues.
Might I just ask a question though, Ms. Kine? You said it was never the intention, but I'm understanding from the applicant and others who support the applicant's case, is that even if that was not the intention, or it was not the intention of GECOM in relation to Order 60, that in actuality, there has been a breach. So they might not have intended it, but there has been a breach. That's my understanding of their case.
Yes, that is what they're saying, Your Honor. But nowhere in that order is there any provision. I mean, I've read this order, and I know Your Honor has read it. There is any provision which establishes GECOM as the High Court to allow it to take evidence. It is not only an order would have to do that, we would have to amend the Constitution of this country to permit GECOM to undertake that kind of evidence base to resolve, to resolve disputes in this manner. GECOM does not have the capacity. In no more, I believe, Your Honor, almost three times in Ali and David's matter, the CCJ reinforced this principle, that the chairman of GECOM was correct in her determination that GECOM could not and does not have the mechanism to resolve these disputes, that the disputes would have to be resolved. Well, I should not call them disputes, the allegations, because at this stage, Your Honor, they are still allegations. The allegations would have to be resolved by virtue of an election petition. The highest court has already said that. So I know, my dear friends, you know, their arguments are premised on the notion that somehow Order 60 is bad in law simply because the GECOM deferred, and GECOM indicated that it could not resolve these disputes in the manner in which they were acting, and that really this would have to be resolved by the High Court. Your Honor, when you look at Order 60, where GECOM says that the order will resolve, or the recount process, Your Honor, will resolve and produce a final credible count, Your Honor, that is the counting of the ballots between what happened, which resulted in the March 13 declaration, and the recount. It was to resolve that, not for GECOM to take upon itself to become the High Court. Certainly, Your Honor, because as the Apex Court said, this would trespass on the exclusive jurisdiction conferred on the High Court under Article 163(1)(b). And the CCJ so found, Your Honor, at paragraph 52 of its judgment. To say, therefore, Your Honor, even if a court, I wish to say, Your Honor, even if a court finds that that small portion of the order was unconstitutional, Your Honor, that does not affect the entire order.
Sorry, what small portion of the order?
No, our submission is that it is not unconstitutional. I'm saying, Your Honor, that even if my friends premise their argument on the fact that GECOM somehow by this order is supposed to become an election court, I'm saying that when the time arises during an election petition, even if a court so finds that a part of Order 60 or a portion of Order 60 was unconstitutional, that does not produce a finding, Your Honor, that the entire order is bad and void ab initio. That is what I'm saying. Because all Article 8 says that anything which conflicts with the Constitution would have to be void to the extent of its inconsistency. So even if we go down the road of my friend's arguments, this does not invalidate Order 60.
But I'm trying to understand what portion you would be referring to.
Well, Your Honor, that is not our submissions. I'm just trying to clarify this. Because when you look at Order 60, Your Honor, no part of Order 60 sets out to make GECOM an election court. The final credible count which the order speaks to, Your Honor, is in relation to the count which led to the March 13 declaration and the controversies which visited. And so as our Apex Court say, to ensure that this new transparent process would produce a final credible count. And Your Honor, 38 and 39. In fact, even if we start from 37 of the CCJ's decision, 37, 38, 39, 40, the court specifically, Your Honor, considered the transparent, credible process which resulted from Order 60. In our submissions, Your Honor, we have stated the process which Order 60 adopted and what different officers as a result were permitted to do as a result of that process. We rely, Your Honor, on those submissions. And we close, Your Honor, subject to the questions which the court may ask, if the court has any. We close with the fact, Your Honor, that, and our submissions bear this out, I've noticed that a number of the respondents have already, they have also made this point, a number of these issues I would say all of these issues have already been litigated. They are just framed in a different manner, Your Honor. Neither can we just go with a contention that is a different party before the court. Your Honor, if we do that, if we say that because the party changes, you can come back with the same issue, our electoral process would never have finality. Because every time a court rules, a new party will come with an application. So, Your Honor, this is a simplistic view and manner to determine the issue of res judicata. Cannot rest on just that there is another party before the court. And I know Your Honor is a mature senior court. It has to do with what are the issues which are being ventilated. And I respectfully submit, Your Honor, that these issues, all of these issues, they have been ventilated either in Yulita Moore's matter or in Eslyn David's matter.
Good. Thank you very much, Ms. Kite. I just have a couple questions. I think Mr. Jeremy was making this distinction, and I had noted it, whether the Moore decision could be read narrowly to say, well, the court was really only considering the lawfulness of GECOM undertaking a recount supervised by another entity, to which we know CARICOM, as distinct from GECOM undertaking a recount, so that if the Moore decision is read very narrowly, is only speaking to the lawfulness of a recount, excuse me, supervised by CARICOM, as distinct from the lawfulness of a recount generally, that their pronouncements in relation to Section 22 and their pronouncements in relation to the recount being for any challenge to the recount being for an election petition would be, to use Mr. Jeremy's words, obiter, or not applicable to the case at bar.
Respectfully, Your Honor, I cannot agree with that narrow interpretation. When Yulita Moore, in her application, she was challenging the CARICOM supervised recount, and the declarations which she came for asked the court to order GECOM to accept the March 13th declarations, which is being asked for here also. May I just say that in passing? To order GECOM to accept the March 13 declarations. When the court, see, the finding of the court is what is relevant to you, Your Honor, because it is during that the court found that GECOM can conduct a recount. The court did not put any limits on the matter of that recount, except that GECOM could conduct it, and that GECOM, all that GECOM must do, GECOM must ensure that GECOM is not basically abdicating, ceding its functions to any other authority. So to now come to say that it was only in relation to that CARICOM recount, Your Honor, that is a very narrow and simplistic way to interpret the decision of the court.
And finally, either way, isn't the principle from Moore that if GECOM or the chairperson's decision can be reviewed by the court, that the chairperson GECOM's decisions can be reviewed by the court if it appears, either GECOM or the chair, they appear to have acted or be acting outside of their constitutional or statutory powers? Isn't Moore espousing a general principle that the court can exercise its supervisory jurisdiction?
Yes, please. That has been endorsed by Moore. The court said the only way that the court can intervene is if there seems to be, if GECOM is either acting in excessive jurisdiction, then of course the court can intervene in a supervisory manner. We have contended here, Your Honor, that when you take all the issues into consideration, that GECOM is not acting in excess of jurisdiction. Because all GECOM is doing is attempting to bring closure to the electoral process after a valid, endorsed, transparent process. So we have addressed that in our submissions. And we have stated that, yes, if there is excessive jurisdiction, but here in these circumstances, Your Honor, GECOM is not acting in excessive jurisdiction.
Well, thank you very much, Ms. Kite. I know we've run a little over time. I've been asking questions. And so we will take, it was meant to be a 10-minute break. I think I'll shorten it to 5 minutes. So we're at 3:30 exactly now. We'll come back at 3:35. Kindly do not come off the call. You can, of course, turn off your video and just take a stretch break. So we return in 5 minutes. Thank you. Oh.
Yeah, chef. Stop like you see you put up the thing there. Are you figuring any song now? You seeing this? Hold on.
Very well. Good afternoon again. And I think Mr. Boston, I was looking for him and I see he's on. So Mr. Boston, please go ahead.
Your Honor, the challenge, Yulita Moore's case, challenge the constitutionality of the Section 22. My argument does not go towards the Constitution, the unconstitutionality of Section 22. My argument will be based on the fact that Section 22 is constitutional and what follows. Now,
just a minute, Mr. Boston. Just a minute, Mr. Boston. Let me just get that clearly. You're saying your argument, Mr. Boston, you've lost your video. Yes. Your argument is that Section 22 is constitutional. Please turn on your mic. Yes.
Yes, I will come to that. I am coming to that gradually. When Yulita Moore was decided on the 5th of April, 2020, on the 5th of April, 2020, there was not in existence Order 60. Order 60 came into existence on the 4th of May. So the Court of Appeal never had the opportunity to consider whether Order 60, which was born out of the womb of Section 22, was stillbirth or dead on arrival. The Court of Appeal did not consider that. The Court of Appeal was considering an argument as to whether that is constitutional. I am saying, assuming that it is constitutional, Order 60, which was born out of the womb of Section 22, is stillbirth for the reasons. What Order 60 came on stream for is to give GECOM the unlawful power to resolve election disputes which Article 163 has put it in the exclusive jurisdiction of the election court. Order 60 is a subsidiary legislation, and subsidiary legislation cannot do certain things. But before I get back to that, I would like to draw your attention to establish the reason behind the birth of Order 60. Order 60 was meant primarily to give GECOM the broom to sweep in an area that was exclusively resolved for the election court. GECOM can't sweep with the broom that has been exclusively resolved for election court. Let us look at, and I hope you will allow me to read this paragraph so as to get the sting of my argument. Dr. Barrett Jagdio's affidavit speaks to the issue and establishes the reason why Order 60 was born. This is what he said.
Just a minute, Mr. Boston. He may say though that, but that could be his opinion. Are you saying that his opinion is a fact?
One has, if his opinion is a fact, I am saying that his opinion sets up the factual matrices having regard to what have occurred before you in the election, in the contempt proceedings. Complaint was made that the Mingo was not complying with your orders.
Yes, but the complaint in that regard was just my understanding, if my recollection serves me right, was the complaint was that he was to produce the statements of poll, that's all.
No, the complaint was that he was reading from a spreadsheet rather than seeking to ascertain the votes cast for each list of representative from the statement of polls. There is when Justice Claudette Singh said to you that if there is any discrepancy between what the political parties has with Mingo's declaration, I will authorize a recount. You have said in Aladar 1, the allegations of compliance with Section 84 is issues for an election petition. So this court cannot shut its eyes to what was going on in the process that brought on this act. If one looks to the preamble in the order, it speaks of disputes. It speaks of disputes. And the disputes that it was speaking about is dispute entirely within the realm of the election court. I will find it difficult to see why this court will seek to shut out the evidence, the affidavit evidence of Dr. Barrett Jagdeo.
Because from what you're saying, it's his opinion.
No, but it is the catalyst. It is the catalyst.
I don't.
What occurred?
But
Yes,
Mr. Boston, how do you know that?
How do we know that? How do we know that?
Yes.
We have to look to the preamble in the order which says you're seeking difficulty arose. What were the difficulty? The difficulty were in relation to what was taking place.
Well, Mr.
Yes,
Boston, that's a very broad statement. The difficulties were in relation to what was taking place.
Because it was in your contempt court. It was in your contempt court. The chairperson made this statement after the complaint she went there based on an application to have her committed to prison for contempt for non-compliance. Now, so it is in that atmosphere, it is in that setting she gave that undertaking.
So I'm understanding you to be saying that the disputes that are referred to in Order 60 speak not to mere tabulation issues, but to more than that, to election dispute issues.
Yes, the tabulation issue was an election dispute issue because the complaint about the tabulation is that the votes that Mingo declared were not the votes consistent with the statement of polls. And those votes, using the words of Dr. Barrett Jagdeo, is these votes had to come from Mars. They were fraudulent. So that was the background.
So you were saying, just a minute, Mr. Boston, then you were saying that we must make the assumption that GECOM decided that there was fraud and therefore issued Order 60.
That is the issue that gave birth to Order 61. This court cannot shut its eyes to that. So when Justice Barnes in the Court of Appeal says that the issue of whether it is unconstitutional must go to an election court, she did not deal with the issue as to whether the order that was born from Section 22 was stillborn. And this court can so deal with it. This, using your words in Oladar, a court cannot shirk its duty in this regard and shelter behind a contention that an election petition should be filed when the case query does not so warrant it. If you were going to find that this order came primarily for the sole reason of resolving a dispute in relation to the election disputes, it is entirely for the election court. Article 162 cannot give GECOM the right to resolve any issue that arises in relation to whether unlawful acts affect the results of the election, whether unlawful acts or omission affect the result. And that is the issue. And that issue was not canvassed before Justice Barnes. So this court has jurisdiction to deal with that. So when my learned friend, they're saying no jurisdiction because Justice Barnes says that it was dealt with and it has to go to an election petition. This issue was not before her. It has arrived for the first time before you. Now, it's my submission that since Order 60 is a subsidiary legislation. It cannot be inconsistent with any legislation. Now, what Section 22 purports to do is to give GECOM the right to legislate, to introduce new legislation. If GECOM can amend all the section in an act, and all the section in an act constitute the total sample space for that act. So any one section, which will be a subset of that total sample space, if you can amend the whole act, then you can amend a section of the act, because it's a subset of all the section. And this is what section, it was done to amend section 84(2). That is the time all the application for recount were rejected because for some reason or not. You have said in Oladar that any complaint as to whether accounting agent request for recount was rejected or not, that is disputed, and it must be the basis of an election petition. So when GECOM proceeded to amend Section 84 to give it the power to recount, GECOM was acting unlawfully because Section 21B of the General Interpretation and General Clauses Act says no subsidiary legislation shall be inconsistent with the provision of any act. If one looks at Mr. Mendez.
Can I just ask a question, Mr. Boston?
Yeah.
Are you saying that Order 60 amends Section 84?
That is what it purports to do. It's giving them the authority to disregard Section 84 and recount when Section 84 says it is final.
But then if it is amending Section 84, then what act is it contravening?
No, if it amends 64 without replacing it, all it has done,
Boston, I'm sorry. If you say it amends, then it must replace it with something.
But
if it amends, it
has not replaced it. What it has done is to make Section 84 ineffectual. So GECOM can act unlawfully and recount votes that were deemed to be final. That is what it was doing. It was deemed to be final. So if you are caught with the Section 84, which says it is deemed to be final, so you have to make a legislation you have to make an order to give you the right to do so. And if one looks at Mr. Mendez's submission, this is what he says at paragraph 42. Respectfully, what GECOM did in this instance by ordering the recount was merely in effect to waive compliance with the strict procedural provision of the RPA GECOM cannot lawfully do that, because in so doing, you are resolving election dispute, which the 163 said can only be resolved by an election petition. And this is what he went on further to say. The substance of the recount was to consist of the counting of ballots. It was to be done under the supervision of the chief election officer. But the brunt of the provision in the order dealt with the procedure which was to be followed for a transparent recording of the votes counted. The procedure was different from that which is required under the RPA, but was substance. You couldn't do that. You couldn't do that. As I have said, the order set up a resolution procedure to resolve the issues raised by the political parties. That is the representation the chairperson made before you in your court. And that dispute resolution order is a trespass on the election court jurisdiction. And this court can so, by judicial review proceedings, find that such a trespass is unlawful, and whatsoever flow from that recount is unlawful and cannot be taken on board. I further submit that GECOM cannot, by a subsidiary legislation, give itself the power to resolve election disputes that arise in course of an election, which said dispute the Constitution has placed in the exclusive jurisdiction of the election court. What Mr. Mendes also said, the order by GECOM was seeking purportedly to recognize the true will of the electorate. GECOM cannot do so by Order 60 because the true will of the electorate was already determined by the certified copies of the votes remitted by the 10 regional officers to the CEO. That represents the true will of the people. Those 10 reports that were sent to the CEO by the RO from the 10 regions. It is only an election court can determine whether the contents of those reports that were sent by the RO from the 10 regions to the CEO were not the true will of the electorate.
Mr. Boston, your time is just about up, and I have a few questions.
Well, I am ready to take the questions. Or whether you want me.
Well, let me give you 2 minutes to wrap whatever else you may have wanted to highlight.
It's my submission that what the recount would have done, or Order 60, was to establish a new regime of valid vote, which it does not have the authority to do by Order 60. The Caribbean Court of Justice in paragraph 52 in Ali and Jagio said with respect to the notion that Order 60 could either impact interpretation of the Constitution or create a new election regime of variance with plain words of the Constitution is constitutionally unacceptable. The Caribbean court did not expressly validate the order. By what? When I say expressly validate Order 60, what I'm saying, it didn't say Order 60 create a new election regime, nor did it expressly invalidate Order 60. And when I say expressly invalidate Order 60, I'm saying Order 60 could not create a new election regime inconsistent with the RP, in as much as it did not expressly invalidate Order 60 by saying Order 60 cannot create a new electoral regime inconsistent with the RP. It impliedly invalidates that. When one looks at what it says at paragraph 46 of the decision, it says it is clear that under the legal infrastructure governing the electoral process, unless and until an election board decides otherwise, the votes already counted as valid votes are incapable of being declared invalid by any person or any authority. And that authority that is now seeking to invalidate votes that were already validated on the evening of the election by the 10 ROs cannot be invalidated by any authority. That what it is saying there, that you see in this instance, Order 60 cannot create a new electoral regime that is inconsistent with the representation of People's Act. So,
this question, well, the first question I wanted to ask though, is that your submissions seem to be in conflict with those of Mr. Jeremy's, because Mr. Jeremy is saying that Section 22 is unconstitutional, and you are saying that it is constitutional.
In as much as I share Mr. Jeremy's position, I am saying alternatively, I am entitled to an alternative position. That is what Mr. Jeremy alternatively, I am saying so, and it is a fact. If it is constitutional, the Court of Appeal never addressed the issue of the stillborn child that came from the womb on Section 22.
So you support Mr. Jeremy's position, but have an alternative view.
Alternatively. Because it must mean something. The alternative view has to have some force.
So which
because Mr. Jeremy did not argue that alternative view.
Okay, so which view are you really supporting? Because, you know, is it Mr. Jeremy's view or your alternative view? I mean, I have to get guidance from you. And Mr. Jeremy is saying I should accept his view. You were saying you began, unless I misheard you, you began your submissions by saying Section 22 is constitutional, because that's why I stopped you and I asked to make sure that I was making a correct note.
Alternatively, this The fact that I'm arguing alternatively does not mean that Mr. Jeremy has not adopted that alternative position.
Oh dear, Mr. Boston, I don't know if you can speak to Mr. Jeremy, but I will hear him later on. But I don't know that he adopted your alternative position, but be that as it may. Very well. You said in paragraph 24 of your submissions that Order 60 conflicts with Section 22. In what way? Just let me make sure that I have that right. Yes. The order made and gazetted on the 4th of May 2020 conflicts with Section 22 of the Interpretation and General Clauses Act. My mistake. My mistake. Is it Section 22 or Section 20, Mr. Boston?
Section 20, Section 20.
Ah,
Yes.
Section 20. All right, I'll make the note. Very well.
And in closing, I'm saying that Order 60 is unlawful. The results obtained therefrom are invalid, and no declaration based on that RICOM can lawfully be the base of a declaration by GECOM.
Just to clarify, you in paragraph 30, you made a statement that said legislation is inconsistent with Section 21B. Which said legislation? I just want to be clear what you're referring to.
Is subsidiary legislation, Order 60.
Order 60, very well.
Order 60.
So you're saying that Order 60 is invalid. All right, let me ask you this question. It's kind of has some resonance with a question I think I might have asked you in the NCM hearing way back. If the votes according to Order 60 were in favor of the APNU-AFC, would you still say that Order 60 is invalid?
Of course,
Okay.
I'm here for fairness. I'm not here to ride any political party path. I am an officer of the court, and I must present my argument based on my interpretation of the law. This seems not to be a one-sided affair, Madam. Boston representing the coalition. Boston is representing the CEO and not the coalition.
All right, thank you very much, Mr. Boston. I think during your submissions, you answered the other questions I had.
Thank you very much, ma'am.
Very much. Mr. Edwards? Is Mr. Edwards there for the fourth respondent, Attorney General, Mr. Williams? Yes.
Yes, please, Madam Chief Justice. Mr. Edwards will address Your Honor in relation to the question of jurisdiction and Section 22 of the Election Laws Amendment Act, 15 of 2000.
Yes, go ahead.
Thank you, Your Honor. Your Honor, if I may be permitted to attempt to answer the question that Your Honor posed to Senior Counsel Jeremy which I understand to be this: whether Your Honor is bound by the Court of Appeal decision in Moore, which says that in matters of the present type, the proper jurisdiction of the court is that which arises in relation to an election petition. Your Honor, our respectful submission, which is in more detail in our written submissions, which part of the record, is that the Court of Appeal in Moore was not concerned with the issue which arises in this case of whether Article 226(7) of the Constitution, which in our respectful view creates and carves out, probably maintains that classic supervisory jurisdiction of the High Court, would permit Your Honor in this matter to assume jurisdiction to hear Mrs. Jones' application. We respectfully submit, Your Honor, that there must have been some special purpose or intention when the framers choose to preclude or exclude GECOM from the ambit of that House supervision in Article 226. The question then would be, Your Honor, what was that purpose? And we respectfully invite Your Honor to decide it as a question of interpretation, which we respectfully frame as this: what did the framers intend by Article 226(7)? Did they intend that any violation by GECOM, no matter how egregious, was to be beyond the supervisory or review jurisdiction of the High Court? For present purposes, Your Honor's Court. Our respectful answer to that question, Your Honor, is an emphatic no. The framers could not have intended that. And that is why they precluded, as I've suggested, or excluded GECOM from the ouster which they have provided for in Article 226. So given or taking the approach of that purposive interpretation of Article 226, the proviso to Article 226(7), we respectfully submit, Your Honor, that this court does have jurisdiction. Even if we take the view that it is a jurisdiction which we might describe as sui generis, it is no less a jurisdiction. Because the question would be, could the framers have intended that in non-compliance by the chairman of GECOM with plain, simple language as appears in Article 1772b, to wit, acting only on the advice of the Chief Election Officer, could that have been the intention of Parliament, that such an egregious non-compliance, disapplication of the Constitution, should have to await an election petition, which is down the road? We respectfully submit, Your Honor, that that could not have been the intention of the framers of the Constitution in their preclusion or exclusion of GECOM from the House in Article 226.
Can I just ask this question, please, Ms. Edwards? I didn't notice the reference to Section 140 of the Representation of the People's Act, which the Court of Appeal did discuss in Moore, which, to use the Court of Appeal's language, provides a shield to GECOM from inquiry other than by way of election petition. So whilst GECOM may be excluded from Article 226 of the Constitution, what do you have to say in relation to Section 140?
That would raise in an acute form, Your Honor, the fundamental doctrine of the supremacy of the Constitution, could 140, Section 140, undermine or dilute or maybe water down, subvert the intention of the framers in Article 226.6? Again, Your Honor, my respectful answer would be that that could not have been the intention. Because at the end of the day, the Constitution is supreme. And not only is it supreme in an ordinary sense, it is supreme in the sense of being supreme at the deepest level of entrenchment in our constitutional structure, and that is Article 8. And so, Your Honor, it seems to us on this side of the divide, the forensic divide, that, as I've suggested, it may be that Your Honor would have to decide that question as one of interpretation in this matter. And we would respectfully invite Your Honor to give a purposive interpretation to 226, the proviso of the 226.7, and to say that you have a jurisdiction which is sui generis, and it kicks in prior to a jurisdiction that is, so to speak, down the road when one wants to bring an election petition, which we understand is classically done after a declaration has been made.
Very well, go ahead.
Turning to the issue, Your Honor, about Section 22 of the Election Laws Amendment Act number 15 of 2000, whether that is constitutional. Our respect for submissions, which again, Your Honor, has been elucidated in detail in our written submissions, is that Section 22 is unconstitutional and has to be severed from the rest of election laws related to it. Why is it unconstitutional? There is, like the separation of powers doctrine, not a fundamental doctrine which we know as the separation of powers. And it seems to us, Your Honor, that it would take the clearest of language, not in some principal legislation, but in an alteration to the Constitution, to seek to transfer from Parliament, which under the doctrine of separation of powers, is the body, the authority, the constitutional body or authority for making principal legislation. It would take a constitutional alteration to transfer such a power to a body like GECOM, which, however we describe it, is at the end of the day and part of the executive arm of the state. GECOM is not part of the legislative arm, and it's certainly not part of the judiciary. So the question would arise, or the question as it seems to me, Your Honor, would be, was Parliament permitted in the Election Laws Amendment Act number 15 of 2000 to seek to transfer its legislative power to an executive body like GECOM? We respectfully submit, Your Honor, that that could not have been the intention of the framers of the Constitution in Article 162. Article 162 is too general, if I may say so, Your Honor, to permit such a revolutionary departure from the classic doctrine.
When you say it's too general, you mean it?
Yes. If you read it, they can be, these are words of generality, Your Honor. Permit me while I...
No, Mr. Edwards, I don't want you to read Article 162, thank you. I'm just trying to find out from you, you say it is too general to permit. If it is general, then it may permit. I thought you might have said it was narrow and therefore did not allow the Section 22s and or the 60s of this world. But if you're saying it's general.
It's too general, Your Honor, to permit the kind of revolutionary departures from the classic doctrine of separation. you could not say that Parliament intended to subvert, well, not Parliament, the framers of the Constitution intended that such a fundamental doctrine as the separation of powers could be subverted or impaired or diluted, watered down by such words of generality. That seems to me, Your Honor, to conflict with the principle of interpretation, which, if my Latin is perfect, goes like this: Generalia specialibus non derogant. The general cannot derogate from the specific.
What is the specific you're referring to?
Well, Your Honor, the specific would relate to Article 177(2)(b), which is the crux of this matter, Your Honor. Article 177(2)(b) is the crux of this matter. 177(2)(b) says that the chairman of the Elections Commission must act only on the advice of the Chief Elections Officer. It couldn't be clearer than that. It couldn't be plainer than that. It couldn't be more specific than that, Your Honor. It could not be more specific than that. And I cannot, for myself, understand my limited understanding of constitutional law. How could the framers have intended that by those specific words in Article 162, they were intending that GECOM, by some order, were to be able to dilute, water down, render nugatory those specific words in Article 177(2)(b). That could not be, Your Honor, with all due respect. So unless there's some question that Your Honor would like to pose to me, I'll defer to my lead counsel, the Attorney General.
Yes, go ahead, Mr. Williams.
Thank you. Please, Your Honor. On the question of 60, that would be your third issue, and the fourth one in relation to the declaration of returning officers within electoral districts. Your Honors, let me first of all indicate that what we have is a report by the CEO that was tendered on the Saturday, the 11th of July to the Commission. And that report was not acted on, as my learned friend said, under Article 177(2)(b). And that's a serious breach of our Constitution. Because in that report, the Chief Election Officer had indicated that the list that had more votes cast for it and a designated presidential candidate was deemed to be elected president, and that candidate was none other than David Granger. It followed that that candidate having been deemed to be elected, then it was the duty. In fact, the chairman of the commission was obliged to then declare him as having been elected under the said Article 177(2)(b). That has not happened, and so we have a constitutional crisis in that regard. Now, Your Honor, connected with that issue is that the directions given, purported directions given to the CEO by the chairman also comes into conflict with the provisions of the Constitution. They relied on Section 18 that purported to say that the CEOs under their direction and control. That kind of language we're surprised to find in legislation in this contemporary age. And I quite frankly, I find it reprehensible.
Mr. Williams, one would think then as Attorney General, you might have piloted legislation to amend it.
But we have done a lot in our legislative
If
5
it's
years.
so reprehensible. Anyway, that's just a side. That's just a side remark. Let's get back to
Yes, please.
let's refocus. Yes.
Yes, Your Honor. So essentially, Section 18 cannot deride the provision of Article 177 2B because one, it's an act of parliament, it's an act of parliament, and its intention are in conflict with Article 177 2B, and therefore, to that extent, as was said in Colin Moore's case, as I cited to you, and in fact in Ali Jagdeo and David's case, more recently in the CCG, that it is void and it has to go.
Just a minute, Section 18 is deemed void in the CCJ decision?
No, the principle that if an act of parliament or subsidiary legislation is intentional or in conflict with a constitutional provision, then it is invalid to that extent, void to the extent of that inconsistency.
I'm understanding you to be submitting. I don't think I have that in your written submissions. If they do,
Yeah, we have that, Your Honor.
which paragraph? You were saying that Section 18 is void?
That section, insofar as it collides with the provision in Article 177 2B. That provision in Article 177 2B says that when the CEO submits it, tenders his advice to the commission, the chairman of the commission is obliged to act only in relation to that advice. So that's very clear.
No, I'm just going to your statement that you said in your submissions in Section 18 is void. Right?
Your Honor, it is void to the extent of that.
No, where in your written submissions did you?
Paragraph 10, for example, is there.
Well, I'm sorry, I don't read it as you saying that Section 18 is void. But I have made a note that you're now saying that.
As well as Section 22, Your Honor, but I'm guided by you. But the issue is we have a situation where GECOM relies on Section 18 to say that they could give directions to Chief Election Officer. Now, Your Honor, that provision, Section 177 2B, was not originally in the 1980 Constitution. It came in 2000 after the debacle that was the 1997 election, where the chairman at that time more or less repaired the room in State House with the person they wanted to elect as president and purported to do so. And so the amendment in 2000 was to prevent a situation like that occurring again. And that is why the provision is now in the Constitution that the CEO, that is, the chairman, could no longer act independently of the CEO. But in fact, the chairman must accept the advice of the CEO.
Let me ask you this question. If the advice is, and I'm not saying it absolutely, it is in this case, but I'm making a hypothetical proposition. If the advice of the CEO is flawed, then what? It must be accepted?
But Your Honor, they will have to go by an election petition if they're saying it's flawed. You know that there was a lot of chatter saying that for the past 4 months, who must go to the election commission. We have a situation under the electoral machinery of this country where the CEO, in fact, is acting in pursuance of relieving this country of that mischief that had occurred in 1997. And having done so, it's inexorable. But, Your Honor, I'm not alone in that.
It seems as though the other side, we have the other respondents. From what I'm reading in their submissions, they're saying the mischief, there's now a new mischief.
I'm guided by your honor. If you wish to disclose that, you wish to. But
That's what I'm reading in the other submission, in the other submissions. Anyway.
I didn't get the submission from Mr. Barjaglio. But what I'm saying, it's a very serious matter. In some countries, very serious. They would look at it differently. But you have a person who's deemed to be elected president. And the Constitution says that its chairman must so declare. But not only that, the CCJ has just said that. In paragraph 37 of its judgment, for Sanders, the president of the court. You know, Your Honor, it says quite clearly there.
No, don't worry to read it. We know it. Everybody is mentioning
so you're familiar that there's no room, there's no discretion. And once that person is deemed to be elected, the chairman is obliged to declare that he is elected president of this country. And that is what, instead of doing that, the chairman has asked for another report and then purported to invalidate the basis of the report of the CEO, which he indicated what the basis was. And let me deal with that now, Your Honor, because it is tied up with the next the question also.
You just have about 2 minutes to tie up.
Yes, please, Your Honor. And look, in 52, paragraph 52 of the CCJ's judgment in Ali Jaggio and David, it's a clear, definitive statement of law by our apex court. It's actually tantamount to a declaration of the law on the point. And it says clearly that no order of GECOM could purport to interpret the Constitution or to decide that it could create a new electoral machinery regime at variance with the existing one. And having done that, the CCJ has gone to show you, starting in paragraph 37, that you have to return to the established electoral machinery that has carried this country all these years. And that inheres in section 96 of the Representation of the People Act. It starts with that, then it continues in paragraph 45 that tells you the officials, you look ex facie in a transparency process and determine whether a vote is valid or invalid. And then you do that in the presence of candidates and of the contested parties and other statutory officials. So there's clear evidence in the judgment of the CCJ, not the executive summary, the judgment, that
this question,
the veneer.
Just a minute, Mr. Question. Do you consider that the CCJ endorsed Order 60 in their decision?
No, on the contrary, it annihilated it. It erased it from the existence of laws in Guyana, and it was actually subsidiary legislation. And it's clear that the veneer that it presented was removed. So that's why you have to go back to the transparent process where votes would have been determined ex facie, that is on the face of it, whether they're valid or invalid. And that process must be done with the statutory officers designated in the legislation. So that's where we are now. So there's no way, and in fact, there was some talk that the court made some consequential order that you can't use one half of the order, but you could use the other half, that is the votes from the recount. That never happened. That's not in the judgment.
Well, Mr. Williams, I do not know what you're talking about.
Okay, Your Honor. But in relation to the recount, the 10 declarations too, it's very clear, the court showed clearly that before an election court decides otherwise, no valid votes that had been determined in the electoral process could be validated by any person or any authority. A clear statement of the law. So unless Your Honor wishes to ask me any further question, I am respectfully submitting that the chairman of GECOM must declare David Arthur Granger as having been elected from the March 2nd general and regional elections as president of the cooperative Republic of Guyana. I thank you, Your Honor.
Thank you very much. We're meant for a 5-minute break. Who's first? I'm quite prepared to go on. So I think the next person is Mr. Khan. Yes.
Good afternoon, Your Honor. May it please the court. I will, as best as I am able to, having regard to the submissions that have gone before, truncate mine so that I deal with only the aspects that I consider to be germane.
Okay.
But
Yes.
before I do so in with any specificity, I wanted to indicate to the court that essential to everything that I will submit to the court going forward, the underpinning is that this is a court of first instance. This is a court that has to absolutely, in every aspect of its deliberation, have regard to what superior courts have decided and determined. It is the foundation upon which our entire judicial system is based. Lower courts cannot simply ignore the rulings of higher courts. With that in mind, Your Honor, I wanted to begin by adverting very quickly to the first part of my submission, which dealt with the issue of jurisdiction. And Your Honor will note that we respectfully take the view that the court does in fact have jurisdiction along the lines of the full court ruling in Jagdeo and Moore, since the court in that particular decision said that not only the respondent had a right to challenge the lawfulness of GECOM's action, but that the court had a jurisdiction to adjudicate in it, but deferred to the special legislative regime set up specifically to deal with it, as is the case here. This particular view was endorsed by the Court of Appeal when it indicated that its jurisdiction only exists in relation to the anismonic exceptions, and that the barrier set up by 141 and 163 prevented inquiry into functions which fall within the responsibility of GECOM in its management of elections process. Your Honor, these are very trenchant words that were laid down by the Court of Appeal, that Section 141 and Article 163 prevents inquiry into functions which fall within the responsibility of GECOM in its management of the election process. An essential plank of the argument that is being made by the applicant is asking, in effect, the court at first instance to do exactly that, to inquire into functions which fall within the responsibilities and management of the election process. And it is for that reason, Your Honor, I believe that notwithstanding that the court has jurisdiction, what is being asked for in this application does not fall within the anismonic exceptions, or alternatively, as the full court has said, is found within the special regime which has been set up to deal with these matters as it relates to election petition legislation.
So, Mr. Khan, you are not agreeing with many of the other respondents in this regard.
I am not, Your Honor.
Very well.
Your Honor, I wanted to then look, and I would ask the court to look at the issue of res judicata at page 6 of my submissions.
Yes, go ahead.
Because essentially, Your Honor, what we have is a situation where we are advocating that notwithstanding that the court has jurisdiction or may have a narrow jurisdiction, when one examines the issues that are being brought to the court, these are issues which have already been adjudicated by the court. Now, it is axiomatic that these actions, the one brought by Yulita Moore, the one brought by Eslyn David, and now the one brought by Ms. Jones, have a certain sameness to them. I know for a fact that the applicants have told the court that their notion of privity enables this sort of litigation to wend its way back to court, whether it's Harry Smith, Tom Jones, or Larry David. But when one looks at the issues that are being canvassed, they are essentially the same. And our Constitution tells us, and I refer the court to, it is Article 163 of our Constitution, which speaks to any person. So if we are to give that a purposive interpretation, it cannot be that when the court has decided an issue in relation to one person, that a second person, a third person, a fourth person can then come to the court and say, well, we were not party to those actions, ergo, we can still bring what is essentially the same issue. Public policy dictates and demands that that sort of litigation ought not to be encouraged or countenanced, or else we will, in the words of private international law, we will be in a situation of circulus inextricabilis. I wanted thereafter, Your Honor, to point out, I know this has been canvassed before, but I just wanted to read back the words of section 40, paragraph 46, when it says that it is clear that under the legal infrastructure governing the electoral process.
Paragraph 46 of the
CCJ's judgment, Your Honor. It is clear that under the legal infrastructure governing the electoral process, until and unless an election court decides otherwise, etc., that the votes are valid. One has to understand what is meant by the legal infrastructure. The legal infrastructure has to include all the laws that are currently in place. It is very easy to come to the court and say that Order 60 is unconstitutional and should be struck out. That is not what is before the court. Order 60 remains an extant piece of legislation that the court has to have regard to. And the fact that it was given consideration at the highest level, but not considered to be unconstitutional, is something the court ought to take into account. It's fairly easy to come to the court and decry Section 22. It is fairly easy to come to the court and, again, decry Order 60. But there's no judicial determination. In fact, what there is an affirmation of the legal infrastructure, in the words of paragraph 46, that it is clear under the legal infrastructure governing the electoral process. That legal infrastructure includes Section 22, it includes Order 60, it includes every single constitutional article that forms part, parcel, and party of what we're dealing with. So that the court, by saying that the legal infrastructure in place speaks to validity of votes, is impliedly saying that you must have regard to what Order 60 says and what it purports to do. Until such time as Order 60 becomes the subject of litigation in itself, because that is not the purpose of this litigation, that says that it is unconstitutional, then I respectfully submit we are not in a position to make that sort of determination here and now. And we have to operate on the basis. Yes, ma'am.
I'm understanding the applicant, the Attorney General, Mr. Boston, on behalf of the CU, to be saying that Order 60 is unconstitutional and the court must address that issue.
I am saying, Your Honor, in response, that the Caribbean Court of Justice has given its imprimatur to quote the legal infrastructure that is currently in place. Those are the words of paragraph 46. And it is not open to this court, most respectfully, to now embark on an investigation of any sort as it relates to whether or not any aspect of the legal infrastructure currently in place that governs the laws is unconstitutional or not.
Well, if it wasn't specifically raised before the CCJ, why can't it be raised?
I agree that it can be raised, but I believe that ultimately it has to defer to the dicta of the CCJ in paragraph 46. One cannot simply speak of the validity of votes without attaching it, so to speak, to the CCJ's observation that these were valid votes under the existing legal infrastructure. That is the essence of the argument that I wish to posit in response. Now, Your Honor, there is two other aspects, because I know that my time is limited and I don't wish to tarry much longer as it relates to other matters which will be dealt with, I'm sure, by other respondents. And that is, Your Honor, before I go there, I wanted to also respond to Mr. Boston's analogy, because Mr. Boston takes the view that Order 60 of 220, in his words, is stillborn. I, however, take the view that Order 60 of 2020 may, in the best of circumstances, had some breathing difficulties. The Caribbean Court of Justice has provided the necessary incubation, which has allowed Order 60 to survive. And what essentially Mr. Boston is trying to do is ask you to throw out the baby with the bathwater. As it relates to the issue of process versus merit, and I refer to paragraph 4 of my submissions, Your Honor, when I speak about the subject of review as distinct from appeal, that it must be circumscribed by an examination of the process and as distinct from the merit. Your Honor, when we examine the reasons that have been proffered by the chairman with respect to her ruling, and this is attached to the supplementary affidavit of Ms. Jones, she says towards the end of her submissions, of her ruling, she says that it is my decision that the results of the March 13th declaration cannot be used at this time, since they are replaced by the tabulation of the votes at the recount process, which was hailed by all to be a transparent and credible process. Now, it may be that you have a difficulty with that decision. It may be that you do not agree with that decision. But those are not issues which, in an application for judicial review, you can strike down, most respectfully. The chairman goes on to say this in relation to 177(2)(b). She says that the Constitution cannot give a narrow interpretation. It must be interpreted purposefully. Purposefully. The CEO is an elections officer who derives his authority from the Representation of the People Act and not the Constitution. And before that, she says that if you read it the way in which my friends are asking you to read it, it would be that any report whatsoever the CEO produces must be acceptable, would be tantamount to elevating the CEO above the commission. And accordingly, she would construe this article to mean the exclusion of persons, groups, or bodies external to the commission. In other words, what the chairman is saying, as I understand her, is that she is bound not simply to accept only the advice, but she is bound not to accept the advice of anyone else. In other words, that advice must come from the structure that is put in place at GECOM.
But my understanding from Mr. Edwards and the Attorney General's submission is that the chairperson cannot decide not to accept the CEO's report. That she's, so they are saying the opposite to what you are.
I am precisely, Your Honor. I am saying that she does in fact have a residuary discretion not to accept that report. And that residuary discretion is found in her constitutional mandate. And it cannot be that she has to accept it when in fact she is the functional superior and the commission is the functional superior of the chief elections officer.
Oh yes, I now remember, but they're saying, but that's for election petition.
Your Honor, again, those may be matters for an election petition, but in these circumstances, having regard to the recount and having regard to the process that is embarked upon, I respectfully submit that those are matters that are germane to be determined in this judicial review application. Because we are looking at the decisions of the commission. We're looking at the decisions of the chairman. We're not looking as to whether or not these are matters which touch and concern the validity of the election itself. This was the important distinction that was made in David when it was sought to import the issue of validity of votes into the qualification of the president. There's a line to be drawn, most respectfully, Your Honor, when we talk about what it is we're looking at in relation to decisions, which comes back to the premise of process versus merit in issues of judicial review.
Understand?
Yeah.
Go ahead.
Yeah. Your Honor, finally, and I know that I will preface with what I'm about to say with the understanding that the court has not had an opportunity to peruse the affidavit in answer filed by my friend, Mr. Boston, on behalf of Mr. Lowenfield. But I would want to, in conclusion, speak a little bit to this affidavit because it raises some issues which I have some challenges with. Now, in this affidavit at paragraph 2, Mr. Lowenfield admits paragraphs 31 through 43, 46, 47, 68, 65, and 68 of the affidavit of Misenga Jones sworn to in support of the fifth state application. When one examines those paragraphs, Your Honor, those paragraphs, and I'm not going to read them out, but the crux of those paragraphs suggests a litany or a series of allegations that what was done at GECOM was not proper, was not appropriate. But we have the situation where the chief elections officer, who is the person in charge of the very process, is now coming to the court to say that the process that I was in charge of, the process that I ran, the process that I actively supervised, and that I must now determine what the results are, is not a good process, that it has all kinds of problems. Yet he comes to the court and says that you must nonetheless accept my advice without more. There are a number of other matters that I would want to canvass in that regard, Your Honor, but to do so would require Your Honor to have a fuller understanding of what the affidavit contains. The second aspect of the affidavit, Your Honor, is that at paragraph 4 of the affidavit, Mr. Lowenfield deposes, quote, that after speaking about the validity of votes, he says that the approach was inconsistent with procedures set out in ROPA and the official manual for presiding officers and other polling day officials, revised 2019. That attached and marked exhibit A1 to 5 is an example of this variance. What are attached to this affidavit, Your Honor, as A1 to 5 are photocopies of ballots, actual ballots.
Well, you know, Mr. Khan, that is why at the very beginning I said, and I'm going to state it again categorically, I am not going to be considering any of that kind of evidence. That is not germane to the issues that I have to decide in this matter. So that's the end of that.
I am guided, Your Honor. I simply wanted to point it out. And I'm guided by the court's view on the matter. because it does raise.
I had the same issues in Holidar. I ruled twice on it. And that's why I said what I said at the beginning of this hearing. So wherever there is any evidence, because of course, affidavits, what is contained there amongst the evidence. If there's any evidence along those lines, I'm not interested in it.
I am guided, Your Honors. That represents the sum total of my submissions. Your Honor, if there are any questions that the court has, I will be happy to attempt a response.
No, thank you very much.
Most good.
We'll take a 5-minute break now, and then we'll start with Mr. Mendez as soon as we return. Again, please do not come off the call. So it's 5 o'clock. At 5 minutes after 5, we'll be back.
As a please, Your Honor.
Very well, Registrar. Mendes is present and ready to go, so we will start. Yes, Mr. Mendes, go right ahead.
Thank you very much, Your Honor. Your Honor, my position from at the beginning and at the end is that you have no jurisdiction to entertain the application, to entertain the prayer for the relief that is being sought on behalf of the applicant in this matter. You have no jurisdiction in these proceedings to determine whether Section 22 is unconstitutional. You have no jurisdiction to determine whether Order 60 is valid. You have no jurisdiction to determine whether the recount is valid. You have no jurisdiction to determine whether the declarations made by Mr. Mingo are valid or not. You have no jurisdiction to determine any of those things simply because the law says that all of these matters are to be determined on an election petition, so that this case is a non-starter. Now, why do I say that so confidently? I say that so confidently because at this point in time, you have the guidance of the highest court in Guyana, that is the CCJ, which has recently upheld the principle that all issues relating to the validity of an election must be dealt with by an election petitioner under Article 163 of the Constitution, which, as you have been reminded over and over, is the supreme law in Guyana. The CCJ has also upheld the principle, which has been followed in the courts in Guyana for time immemorial, that matters pertaining to the validity of election must be raised after the election has been declared and not before. And that is a principle that was upheld by the CCJ in the Eslin David case. But even more so, you have to contend with Section 140 of the Representation of the People Act. Now, I heard Mr. Edwards, speaking for the Honorable Attorney General, direct your attention to Section 226(7) of the Constitution, and 226(7) of the Constitution essentially exempts the Elections Commission from the operation of the ouster clause in 226(6). But Mr. Edwards did not read the proviso to Section 222(7). And I would advise you, Honorable Chief Justice, to look at that proviso because it says, provided that
222 or 226(7)?
26(7).
Proviso 226(7)
says, provided that without prejudice to the power of Parliament to make provision in relation to the functions of the Elections Commission, in the preceding paragraph, that expression does not include the Elections Commission. So it says it doesn't include the Elections Commission, so it means that, I'm sorry, my lady, there are some sirens passing by near here. I'm not drowning out what I'm saying.
I'm hearing you clearly.
Thank you very much, lady. Yes, and so it says specifically that even though the Elections Commission is being exempted from the operation of the ouster clause in 226(6), it is saying that it is without prejudice to the power of Parliament to make provision in relation to the functions of the Elections Commission, and Parliament has done so under Section 140 of the Representation of the People's Act, and it has done so very clearly. The functions of the Commission, the exercise of the functions of the Commission, as the Court of Appeal has said, even when it omits to do something, are not to be inquired into by this court except on an election petition. Now, more specifically, in the Ulita Moore case, the Court of Appeal has specified certain things that the court cannot inquire into. And those things are specified in paragraphs 85 going on to 89 and also in paragraphs 106 and 107. Because although the court said, generally speaking, that 141 would not protect the commission where it acts unconstitutionally or unlawfully, it then went on to say, however, Section 1, this is at paragraph 108 of the judgment, however, Section 140 is effective in excluding the court's intervention in relation to functions which fall within the responsibilities of GECOM in its management of the elections process. So that's the exception to the rule. Now, I would respectfully submit that even the first part of the Court of Appeal's decision in Ulita Moore has now been overtaken by the CCJ's decision in Eslin David, and I'll come to that in a minute. But the point is that the Court of Appeal of Guyana has said unequivocally that and this is in paragraph 85, that whether the time had come to proceed under 177 and section 99, and the decision whether to hold a recount, are not matters that were central to the election and falls squarely within the domain of GECOM to determine as part of the management of this election. And those are the things that the Court of Appeal has said are exempted from review in accordance with section 140. And Milady, I will not go on to read 86, 87, 88, which just elaborates upon what the Court of Appeal says. But then section 106 comes along and says, following Petrie, following Sikumar, that the court will not determine the constitutionality of legislation except under an election petition. And then you see in 107, it says specifically, alternatively, if GECOM has utilized or utilizes its power under section 22 unlawfully, then this would be a question for determination at such time. That's what she's saying again. So all of those things are referred to the election court under an election petition. All of the questions that are being asked or you are being asked to determine in these proceedings are questions which the Court of Appeal has already said are to be asked under an election petition.
But my understanding of the argument on the other side is that whilst the Court of Appeal did not prevent a recount decision being made or a recount being held, because of course in more there was an application for injunctions. Nevertheless, the court did not have to deal with Order 60, and therefore they're drawing that distinction, that the ability to do the recount and the actual recount pursuant to Order 60, there has to be a distinction there, and the court did not have Order 60 to deal with.
Well, of course, that is in fact so, Your Honor, but the history of the matter is that GECOM had made a decision to carry out a recount. It was in the process of finalizing that decision by way of order when Ulita Moore intervened and came to court. And because of the question of the constitutionality of Section 22 only arose because GECOM was proposing to make an order under Section 22 for the recount. That is why the argument was made before the Court of Appeal that Section 22 is unconstitutional. And therefore, any order made under Section 22 would also be unconstitutional. And the arguments were also made before the Court of Appeal in Ulita Moore, the very same arguments that are being made before you now, that any order made under Section 22 cannot be retroactive, that it cannot relate to transactions already completed. All of those arguments were made in the Ulita Moore case. As a matter of fact, they are repeated in the written submissions on behalf of the applicant, word for word, from the submissions that were put before the court in the Ulita Moore case. And of course, our responses to them are also word for word. It's a matter of cutting and pasting to save time. But the point of the matter is that the very same arguments that are being raised now as to the constitutionality of Section 22, as to the constitutionality of an order for recount, were made in that case, and the court said very clearly and very specifically that that is a matter that falls under the management of the elections and must be dealt with by way of an election petition. Respectfully, Milady, a distinction cannot be made between on the basis that, well, in that case, there was not an order called Order 60, but there is one now called Order 60. In both cases, the commission was saying that it was going to act under Section 22, it was going to make an order under Section 22. In Ulita More, they intervened before the actual order was made. In this instance, the order was made, and these proceedings are now being commenced belatedly. My lady, there is no way, there is no basis upon which one can make a distinction between this case and that. What the Court of Appeal did in the Ulita More case was not to resolve a dispute in personam. What the Court of Appeal did was to interpret the legislation. And once it interprets the legislation, in this instance, Section 140, and it determines what Section 140 prevents the court from doing, it applies to all cases. And Ms. Jones can't come to say, well, I was not the party to the Ulita More case, and therefore that decision does not bind me. Once the court interprets legislation, it binds everyone. And you can't relitigate that, those points here. So with all due respect to my learned friends, the Ulita More case is not distinguishable at all on the basis that Order 60 had not yet come into being. What Order 60 did was to order a recount in the same way that the commission was proposing to order a recount in the Ulita More case, but it was stopped by the proceedings that were commenced. Now, my lady, the only basis upon which the Court of Appeal felt itself able to intervene in that case was because the proposed recount order gave CARICOM a supervisory role, and that was the only respect in which the Court of Appeal thought that it could intervene. But in respect of all of the other arguments that were made with regard to the validity of the recount order, those were not acted upon, and in effect, the court allowed GECOM to proceed with the recount. Now, as far as the history of the case is concerned, it's important to appreciate this. The recount then proceeded, and 34 days later, the results of the recount were tabulated and presented to GECOM. When GECOM took the decision that it was going to require the CEO to prepare his report in accordance with those results, a challenge was made by Eslyn David. And the challenge was made not on the basis that the order 60 was invalid. As a matter of fact, the position that was presented to the court by the same attorneys who appeared for Ulita More, the same attorneys who appeared for Eslyn David, and now the same attorneys who are appearing for Ms. Jones, they were saying that Order 60 was a valid order, and indeed the Constitution had to be interpreted in order to give effect to Order 60. That is the position that they were taking. No party that appeared before the Court of Appeal in the Eslyn David case or before the CCJ suggested at any point in time that Order 60 was invalid. The dispute before the CCJ had nothing to do with the validity of Order 60, and therefore I'm quite surprised that anyone is suggesting at this point in time that anything the CCJ said could bear upon the invalidity of Order 60. That was never in dispute. And it would be quite a remarkable thing if no one before a court raises any question concerning the validity of delegated legislation, but the court nevertheless, not even expressly, but by some side wind, some interpretation that someone wants to put upon some words here and there in the judgment, means that Order 60 is invalid. That is simply not something that is permissible at all. That is not how disputes are resolved in a jurisdiction such as this. Now, my lady, the other aspect of the CCJ judgment that is important is that, as my learned friend Mr. Khan pointed out, the CCJ did say that as far as the concept of valid votes are concerned, those are to be determined by the regime that is set up for the determination of valid votes. And I endorse respectfully what my learned friend Mr. Khan said, that the regime that exists in Guyana at this point in time includes Section 22 of the Election Laws Amendment Act. It includes, therefore, any orders that are made under that section, and all orders made under that section until set aside are lawful. And so therefore, the system that is in place at this time for determining valid votes includes the recount that has been ordered under Order 60 until set aside.
Well, I think Mr. Mendes, that's why they're saying that this court should set it aside.
But the point is that what Ulita Moore says, I'm sorry, my lady, what Ulita Moore says and what the CCJ is saying, that you cannot consider the question of setting aside that order. You cannot consider the question of the constitutionality of Section 2 or the validity of Order 60, except under an election petition. The point being that once these are the rules that are in place in an election, these are the rules that must be followed to resolve the disputes in the election in order to produce a result. And if it is somebody then says, well, the orders that you made, the legislation that you acted under, the steps that were taken are some way unlawful or unconstitutional, from Petrie to Sikumar, to Eslin David, to Ram, to Ulita Moore, all of the courts have spoken in one voice. These disputes must be taken before the election court. For the time being, until those orders are set aside, that is the law in Guyana. And that is the law that must be used to determine the validity of votes. And that includes the Order 60. It includes, therefore, the recount. That is the basis upon which the parties must act. If it is, milady, that the parties can come whenever they want to the court to pick apart some part of the process because they think it is invalid, then elections will not ever end and you'll never get to a result. That is the system that is in operation. You must await the end of the election. You must wait a declaration of the result by the bodies who are entrusted by the Constitution with the powers to determine the election result. And if you are unhappy with what is done, you then go to an election petition. As it is, GECOM has the power under the Constitution to make orders when difficulties arise. Nobody has suggested that a difficulty hasn't arisen. It is empowered to do so. It has done so. And that is where we are. With respect, my lady, you have no jurisdiction to enter into any inquiry of these questions at this point in time. And that is what, respectfully, you must say. Now, I wish to make this additional point. It is telling that as far as GECOM is concerned, that is the commission and its members, Section 140 focuses laser-like on its functions and says that you can only challenge the validity of their functions in an election petition. It says that very clearly. There isn't a similar Section 140 in relation to the CEO or in relation to Returning Officer Mingo. There isn't a section like that. But the reason why their decisions and their actions can only be challenged on an election petition is because of the general principle that the CCJ has recently upheld in the Eslin David case, that you must wait for the election petition in order to raise these issues. But the point is that the legislature thought it sufficiently important to pass a specific provision to say, as far as GECOM is concerned, don't interfere with what they're doing. And this is what I believe that the Court of Appeal in Ulita Moore was trying to underline. They were trying to say, leave it to GECOM to resolve these disputes and bring the election to an end. And if you have any problems, then you go to the election court in order to determine otherwise. Now, the reason why I say that the Court of Appeal decision, that there is some leeway to challenge the GECOM's decisions before the election is at an end. The reason why I say that has been overtaken by Eslin David is because in making the general statement that you must raise disputes concerning the elections only in an election petition, the CCJ footnoted Section 140 of the Representation of the People Act. You see that in footnote 50 to paragraph 47, which I won't read again because it has been read for you from time to time. And indeed, the argument was put before the court that Section 40 was a complete ouster And all of the authorities that had been cited to the full court, if you recall, milady, in the Ulita Moore case were cited. All of the authorities that say that Section 40 is not a complete ouster and therefore is not covered by anisminic. All of those arguments were made before the CCJ, and it is telling that in saying that disputes must go before the High Court under Section 163, they footnoted 140. Respect is not necessary to resolve that issue at this stage. We say that Ulita Moore has now been overtaken by Eslyn David. You don't need to make that finding. All you need to do is, I respectfully submit, is to look at those paragraphs in which the Ulita Moore, the Court of Appeal of Guyana said very clearly that these are matters that must not be entertained by this court at this stage. Now, the one point that my learned friend Mr. Jeremy made that is worthy of consideration is that there is a dispute now. There is a dispute between the CEO and GECOM as to which votes are to be used in order to declare the election. And what Mr. Jeremy is saying is, what do we do in these circumstances? How do we resolve that? Well, the applicant didn't just come innocently to the court to ask the court to resolve the issue. As a matter of fact, the applicant took sides. It came to say that what GECOM was doing was unlawful. And it came to say what the CEO was doing was lawful. So they obviously took a side in that dispute. But milady, to answer my learned friend Mr. Jeremy's question, what do you do to resolve this impasse at this point in time? It's very simple, milady, and this is as much as you can do, I would respectfully submit, is to refer the CEO to Section 18 of the Election Laws Amendment Act, because that is where the dispute is resolved. Section 18 says very clearly, the Chief Elections Officer and the Commissioner of Registration shall, notwithstanding anything in any written law, be subject to the direction and control of the Commission. So as much as the CEO might think that he ought not to act on the recount that he himself supervised and he himself tabulated the results and put it before the commission and called the votes himself, in his words, valid votes, as much as he may not want to act in accordance with that recount at this point in time, as much as he may presumably genuinely believe that the recount votes are not to be acted upon, for the time being, he must obey the law. And the law says that he must act under the direction and control of the commission. He's a public officer and he must obey the law. And he must, at this point in time, reserve his opinions as to what is right and what is wrong, and leave it to the court under Section 163 to determine whether his viewpoint is right. That is the only way to resolve this impasse at this point in time, milady. And that is as much as this court can do, to direct the CEO to Section 18. You cannot determine whether Section 18 is constitutional, because again, that would be doing the very same thing that the Court of Appeal of Guyana says that you must not do. You cannot determine the constitutionality of Section 22. You cannot determine the lawfulness of Order 60. None of these things can be done at this stage. The CCJ has made that very clear. Get the election over, get a government that reflects the will of the people into office, and then resolve all of these legal disputes later on. That is what the law requires, milady, and that is what you are bidden to do as a first instance judge with judgments of the Court of Appeal and the CCJ there for your guidance. And of course, I would commend to you your decision as well in the full court in the Ulita Moore case, which I respectfully submit has now been upheld implicitly by the CCJ in the Eslyn David case. But as I said, that is just by the way, because you don't need to determine that point at this point in time. I'm not too sure how I'm running for time, but there's just one thing that I thought that I couldn't let pass without comment. I thought I heard, I don't know if it is that the technology failed at that point in time, but I thought I heard Mr. Boston said that the true will of the people is reflected in the declarations? Is he saying the true will of the people is really reflected in Mr. Mingo's declaration? Is that what he said?
Because, Mr. Mendes, as I said, I'm not getting into those issues.
Oh, well, I'm glad, my lady, because I wouldn't want to have to comment on that statement at all. But that is what I thought I heard you say. But at the end of the day, my lady, we say you have no jurisdiction. But of course, I just wish to say we rely on our written submissions. The remainder of our submissions were premised upon the court deciding that you have jurisdiction. And then we said, well, if you say you have jurisdiction, we have put forward our submissions as to why Section 22 is not unconstitutional. I don't know how anybody could interpret what we have said as a concession that it is unconstitutional. We said it is not unconstitutional, but just as lawyers always do, we say in the alternative, if you don't agree with that, then the Constitution bids you to sever. It says that it's inconsistent to the extent of it's void to the extent of the inconsistency, which requires you to consider severance, and therefore we made submissions along those lines. But we also went on to make the point that in any event, Order 60 in this instance is not or cannot be held to be invalid, because whenever a public authority does something that is not completely in compliance with the law, the question is, did Parliament intend the result to be invalid? And I have set out all of the authorities in relation to that. It's just simply because you don't follow a provision under an act, it doesn't mean that your act is invalid. You now have to ask the question, did Parliament intend invalidity? And we respectfully submit that it is plain that what the recount did was to try to find out what the will of the people of Guyana is. And that is the purpose of the Representation of the People Act. And it would therefore be a remarkable thing if Parliament intended that when you go through such a transparent process, a process that the highest court has declared and commented is transparent, that when you having gone through that process and you determine that the will of the people of Guyana is that a particular party form the government, on what basis can you say that Parliament intended that result to be invalid? Simply because you didn't follow the exact provision.
They have the will of the people.
Sorry, Melanie.
That each side is saying that they have the will of the people.
Yes,
so that's
lady.
why I'm not concerned with that aspect of it.
I appreciate, my lady, but you appreciate that.
I did not make the specific note of as to what paragraph in your submissions, but I do have a question here. Why do you say that Order 60 did not purport to amend any law?
Lady, because it doesn't say, and I think that this is a question that you were asking Mr. Boston. It does not say that Section 84 of the Act is amended by deleting the following words, or by deleting the following words and replacing it by these words, or by deleting these words and adding on another paragraph. It doesn't amend it in that way. What it does is to say that there is to be a recount to follow a particular procedure. And the point being, my lady, that the context in which Order 60 was made was one where there were requests for recounts that were denied by Mr. Mingo in relation to District 4 in particular. And he denied it on the basis that the counting agents who are supposed to request a recount had been appointed too late, or the notification was not proper, or more than one counting agent had been, and so on. That was the backdrop to Order 60. And what we are saying, milady, is that what in effect the GECOM did was to say, well, despite those procedural errors, we are still going to have a recount. That's what they said. They didn't amend the legislation. What they effectively said is, despite those non-compliances, as it were, we are still going to order a recount. Sorry.
Okay, final question.
So if I may just make that point before your question, lady, at paragraph 38 of the CCJ's judgment, they make the point that Order 60 relates only to the elections held on the 2nd of May 2020, and of course that is what Order 60 relates to. Doesn't amend the legislation at all. I'm sorry, my lady.
Oh, just let me make that note.
That's paragraph 38 of the CCJ's judgment.
Yes, final question. I might have asked it before of others and may have asked it before, but I'm getting the sense from the applicant, Mr. Boston, Attorney General, Mr. Edwards, that they're saying that the chairperson is acting unlawfully in writing the CEO to say what he must present to the commission. Is that so? And if so, can't the court inquire into that?
Well, first of all, my lady, once again, that is not, you have no jurisdiction to inquire into that at this stage. But again, if you are assuming jurisdiction, then my answer to it is as follows: that there is a valid order that has been made on the face of it, that is Order 60, which you cannot inquire into, the validity of which you cannot inquire into. That order said that there must be a recount. Mr. Lowenfield presented a report with the results of the recount. GECOM has taken the position, obviously, that the order that said that you must have a recount obviously supersedes anything that went before it. And under Section 18, and indeed under the order, because the order itself said, Order 60 said, that it is for GECOM to decide whether they will require the Section 696 report in accordance with the recount. And they have decided so. So they've made the decision under the order that they're going to require a report under Section 96 in accordance with the recount. And they have done so. They've written to Mr. Lowenfield and they told him, prepare your report in accordance with the recount. In other words, they're satisfied with the recount. They're satisfied with the results. We therefore require you to prepare the report in accordance with the recount. And then they have the power under Section 18 to direct Mr. Lowenfield to do just that. So if the question arises is, if you think you have jurisdiction to answer that question, my lady, then the answer is that acting under Section 18, they have, and the order, they have the power to tell Mr. Lowenfield to act in accordance with the recount. Just as, my lady, even if you had no recount, and Mr. Lowenfield decided that, you know something, I am not going to act in accordance with the declarations provided by the returning officers. I am going to invalidate 115,000 votes of those declarations. If he decided to do that, for example, I'm invalidating 115,000 votes, something which the CCJ has just said in Esslin David that he cannot do. If they were to do that, and he's presenting a report on the basis of the invalidation of 115,000 votes, then the authorities that I've put before you, where governor generals or presidents are required to act in accordance with the advice of the cabinet, the law is very clear. If the advice that is being given is unlawful, then the governor general or the president is not obliged to act in accordance with it. And the court will uphold the decision of the president or governor general in those circumstances. And I think that that is what informed the question that you had asked earlier on the hypothetical question. If you may be required to act in accordance with the advice of someone, but the presumption of the law is that the advice is itself unlawful. And that is, again, that is why you have Section 18. If it turns out that there's a rogue CEO who is ignoring the declarations that have been made and giving his advice on the basis of something that he invents himself, then GECOM is entitled to say, well, I can't act on that because that will be unlawful. And that becomes part of GECOM's power to manage the elections, which the Court of Appeal has said that the court will not inquire into until under an election petition. In other words, the court must leave it to GECOM to exercise the powers that it has under the Constitution and under Section 18 to manage this election to a result that GECOM considers to comply with the law.
Good. Thank you very much, Mr. Mendes.
Much obliged to you.
Mr. Ramkaran?
I'd like to start with res judicata. Res judicata exists to bring finality in litigation. And if ever there was an issue which needed to be brought to finality, it is these elections. Now, there's one sense of res judicata as issue estoppel, where there have been one set of proceedings and issues either of law or of fact have been determined, those issues of law and fact will be applicable in later proceedings. So if the issues have been determined in the earlier proceedings, whether of law or of fact, in later proceedings, those issues have already been determined and the issue is res judicata because it is an issue estoppel. The question to be asked is whether the determination of the issue in the earlier proceedings was an essential step in the court's reasoning so that it can be inferred that in the later proceedings, the matter has already been determined. If it is that the particular decision could not have been reached, or unless a certain finding of fact were made or principle of law applied, then it is inferred that the matter is res judicata by issue estoppel. Both in the cases of Moore and David, issues which are raised, issues of fact and issues of law which are raised in these proceedings have been determined. This includes by implication, the CCJ did not explicitly determine these issues in David, but by implication, it determined the validity of Order 60. It went through Order 60. If there were any sense on the part of the CCJ that Order 60 was invalid, it would have said so. So by implication, it determined the validity of Order 60, and also by implication, it determined the validity of the recount. If Order 60 was valid, if the recount is valid, then those issues cannot be raised in these proceedings. Also by implication, the CCJ determined what the chief election officer should put in his report by determining what he did put in his report was unlawful. So by implication, we know what was unlawful, so we must know what is lawful. In addition, the invalidity of the original declarations by the returning officers have already been determined, also by implication, because if it is that the recount is valid, then it must be that the declarations made by those returning officers are invalid. So all of these issues have been dealt with either as fact or as law or as a mixture of fact and law by the decisions of Ulita Moore in the full court and in the Court of Appeal, and by the decision of David in the Caribbean Court of Justice. For the applicant to now bring them again in this case would mean that she is estopped. She ought not to be heard on these issues which have already been determined and are the subject of a res judicata. And the court should summarily dispose of those issues which it believes have either been expressly or by implication determined in previous litigation. Another sense of res judicata is as an abuse of the process of the court. In order for the court to find that such a res judicata exists in this case, the court must find that the applicant is in a relationship of privity with the other applicants, Ms. Moore and Ms. David. She must have some legal or beneficial interest in the previous litigation. The learning is that this is a matter of substance, not of form. So the court does not necessarily have to look at issues of form that there is some sort of form where she is an agent or a representative. She might simply be privy because of the circumstances existing in the case. For example,
Mr. Ramkaran, isn't that an evidential issue?
Your Honor, there is certain evidence. It is an evidential issue. It is an issue either of evidence or of judicial notice. And I understand that this is not an easy finding to make, an easy inference to make. But it is open to Your Honor to look at all of the circumstances, determine whether Your Honor wants to make this finding. Some of the issues Your Honor can look at are well, first of all, each of the litigants have an interest in the re-election of the government. That might be too wide an issue. Now, Mr. Jagdeo has put in a supplementary affidavit, which Your Honor has said you have not seen. It exhibits a statement of poll which shows that the applicant in this case.
I'm not interested.
Pardon me, Your Honor?
I'm not interested in anything that is.
Certainly, Your Honor, but if Your Honor were minded to consider it, Your Honor, it was open to Your Honor to find that the relationship of privity exists. And if a relationship of privity exists, then it would be an abuse of the process of the court to relitigate these issues which have already been determined in the previous cases. So such issues would include the constitutionality of Section 22, the validity of Order 60, and what the legal effect of the declarations of the returning officers is. These issues, Your Honor, in this heading of res judicata, ought to have been taken in one set of proceedings rather than being litigated in successive matters. I know that the court is very familiar with this area of law, having analyzed Dave Narayan Prasad, having analyzed the issue in Dave Narayan Prasad and Citizens Bank in 2014. And of course, if Your Honor is willing to find the privity, Your Honor can summarily dispose of issues which ought to have been taken in the earlier litigation. In relation to res judicata, Your Honor, the principles are set out at length in Virgin Atlantic and Zodiac, reported at 2014 appeal cases, page 160, as part of my authorities at paragraphs 17 to 26, and I recommend it to Your Honor. Your Honor, on the constitutionality of Section 22 of the Election Act, the Court of Appeal has already recently held that the constitutionality of Section 22 should be determined in an election petition in more at paragraphs 105 to 106. Nevertheless, the argument raised by the applicant has no merit if Your Honor were to consider that you should determine it or you could determine it. This issue was extensively analyzed in Partner Cells Scabet Parsifal against the Attorney General of the British Virgin Islands in 2018 by Her Honor Justice Ellis. And I've put the case before Your Honor.
Yes, I do have it.
In the first place, Your Honor, the applicant has the very difficult task of overcoming the presumption of constitutionality. The court has to ask itself whether it's clear beyond reasonable doubt that Section 22 transgresses the limits laid down by the organic law of the Constitution, whether Section 22 is so arbitrary that it constitutes the execution of a forbidden power, and does Your Honor feel a clear and strong conviction that Section 22 is incompatible with the Constitution? If the answer is no to these questions, then the applicant has not overcome the burden of proving that Section 22 is unconstitutional. Justice Ellis held at paragraph 39 of the decision that it cannot be denied that lawmaking powers can be exercised by a properly delegated executive. Now, the Elections Commission is not the executive, it is an independent constitutional body, so this is distinct from the giving legislative powers to the executive. Justice Ellis also quoted Lord Diplock in Hines against the Queen, which is relied upon by the applicant, where he said that the Constitution does not normally contain any express prohibition upon the exercise of legislative powers by the executive or of judicial powers by either the executive or the legislature. And such an exercise is not uncommon in Guyana. There's a tax appeal tribunal and the Public Utilities Commission, which are parts of the executive, and they exercise judicial powers. There's the Rules Committee, Rules of Court Committee, which exercises some legislative powers, and it's a judicial body. At paragraph 40, Your Honor, Justice Ellis quoted the Privy Council in Hodge against the Queen as saying the legislature retains its powers intact and can, whenever it pleases, destroy the agency it has created, set up another, or take matters into its own hands. So the legislature is free to remove at any time the power given to the Elections Commission under Section 22. It's not an unfettered power which can never be removed, which the legislature has given up and will never have again. If it believes that it doesn't want GECOM to exercise that power anymore, it can easily remove it. At paragraphs 63 and 64 of the decision, Your Honor, Justice Ellis said that the judicial authorities make it clear that it is generally not constitutionally improper for delegated legislation to amend acts of parliament. She said that the guiding principle is that the policy and principle relating to the exercise of the power must be enunciated either expressly or by implication for the guidance of the delegate. So the legislation must say this is what your power is and this is what you must do. In my submissions, Your Honor, I've gone through how narrow and constrained the power under Section 22 is. And it is clear in my submission, Your Honor, that Section 22 must have been meant to give effect to Article 162(1)(b). The power to remove difficulties is to ensure fairness and impartiality in compliance with the Constitution or provisions of the law. So in my submission, Your Honor, Section 22 is constitutional, it's reasonable, and it's necessary. Without it, difficulties, especially when Parliament is dissolved, would be insuperable. You could not ever resolve such difficulties. But with the power, GECOM can easily resolve difficulties in its way and get elections brought to an end. On the issue of jurisdiction, Your Honor, it is clear that the issues raised in this case must be dealt with by an election petition through the combination of Section 141 of the Representation of the People Act, Section 31 of the National Assembly Validity of Elections Act, and Article 163. This has been said by everybody. And the Court of Appeal submission, Your Honor, didn't change this well-established regime in more. It seems to me that its decision was limited to the special circumstances of that case, where it may have felt, and if Your Honor looks at paragraph 110, Your Honor will see that it felt that the Commission was about to surrender supervision of the proposed recount to an external body. So it may be that that was the Court of Appeal's main concern, and that is what it wanted to prevent. But even if, Your Honor, the Court of Appeal created an exception to the election petition regime, the CCJ in Jadeo and David says after more, unambiguously at paragraph 40, speaking about election petition regime, this process and utilization of it are fundamental to the electoral system, the legitimacy of elections, and democratic governance in Guyana. So the CCJ makes it clear that the election petition regime is what must be utilized. It is through an election petition where we can resolve any and all of the issues that are raised in these proceedings. And it is to an election petition we must go if issues of this sort are needed to be resolved. An election petition, Your Honor, as you are well aware, can only be brought after elections are over. And I would urge Your Honor in the circumstances to dismiss this application. Summarily, it is without merit and it only serves to delay the declaration of results. Unless there are any questions, Your Honor, those are my submissions.
Thank you very much, Mr. Ramkaran.
Thank you.
Mr. Jonas? Is it Mr. Jonas? Sorry, I think I've missed.
I think you may have jumped Mr. Ramkaran, Your Honor.
Ramkaran, Senior Counsel, sorry. Yes. So let me find. Mr. Ramkaran, Senior Counsel. All right, whilst he may be off the call and we will try to contact him. Mr. Jonas, please go ahead.
Thank you, Your Honor.
Sorry.
Okay, I think that maybe it's my staff. The registrar calling Mr. Ramkaran. Yes, Mr. Ramkran, go
I'm
right.
available, Your Honor.
Yes, go right ahead.
My apologies for this. Your Honor, one of the most important issues in this matter is the power of the Chief Election Officer. Under Article 177(2), on whether he can instruct the commission under that power or advise the commission on whether his advice is bound to be accepted. Mr. Williams, in his submission, referred to a mischief or a debacle.
You're on mute. You're on mute. They're not hearing you.
And I would like to refer, Your Honor, to the real mischief. The real mischief was the 1980 Constitution, which provided that the Article 177(2), which provided that a presidential candidate shall be deemed to have been elected as president and shall be so declared by the chairman of the Elections Commission. B, where there are two or more presidential candidates, if more votes are cast.
Mr. Ramkaran? Mr. Ramkaran?
In which there's no indication as to who is to decide and what the procedure was for the declaration. It was completely empty of any formal procedure to declare a presidential candidate. And that is why in 2000 or shortly thereafter, the provision as to the CEO having the power to make a declaration and to formalize the procedure by presenting it at a formal meeting. But the principle of the candidate, one candidate obtaining more votes than the other still remained. So the issue was not that the results of the elections must be accepted by the CEO, but that the CEO is the person who is to present the results. And that is how I respectfully submit that section ought to be interpreted. It was the CEO who had to present that results, because if the CEO were to have the sole authority to determine who becomes the president of Guyana, the reforms which were made to the elections management procedures since 2000, the spate of reforms which took place subsequent to the report of the elections reform, the commission, the election commission report, the election reform, constitutional reform commission report, the spate of reforms which took place since then would mean absolutely nothing. And Your Honor, it is because the CEO had that sole authority prior to the reforms that these reforms came in. And if Your Honor were to look at the Constitutional Reform Commission report, I'm not going to read it, you will see the background to the recommendations for reform which were made. That's a public document. It was laid in the National Assembly.
Except Mr. Ramkaran, we really don't have time to go all the way back there.
I'm not taking you there, Your Honor. I'm not going to an excursion into history. I just mentioned it in passing. Your Honor, another reform which is of importance to this case is article, I think is 163(2), which gives the Elections Commission the power to make such laws, to make such orders, and give such directions to ensure impartiality and observance of the rules. Your Honor, that is a wide authority which was given to the Commission. And Your Honor may remember that prior to that article, all the power that the Commission had was contained in the first subsection of that section, which was that the Elections Commission had the powers of general direction and supervision over the elections. That was all it had. It has since had, since the 2000 reforms, this large power contained in the next subsection, and a power that was subsequently added over the registration of electors. And then the Election Laws Amendment Act came into force in 2000, which provided the Commission with powers under Section 18 to direct the Chief Election Officer, and under 22 to make subsidiary legislation and make orders under that section. So there's a fullness of power which was given to the Elections Commission, sometimes not drafted in the way that we all would have wanted, not with great clarity, but certainly with purposefulness. And that purposefulness was to ensure that the Elections Commission itself had power to do what was necessary for the proper conduct and the fair conduct of elections. Your Honor, the cases of P3 and Sikumar Singh have stood the test of time and are still relevant and appropriate today. And in both cases, the laws were challenged. Constitutional amendments were challenged in the Sikumar Singh case, as in this case. And that is, the unconstitutionality of amendments were challenged in the Sikumar Singh case, as in this case with Section 22. Chief Justice Bollers had absolutely no doubt, Your Honor, that Article 71 then applied to the matter, and that Sikumar Singh had to go to the election court. It was alleged by the applicant, Mr. Jeremy, that in that case, the results of the elections were on the board, were challenged. And that is why the cases suggested or decided that election petition was the appropriate procedure, was the lawful procedure. Your Honor, if the CEO in this case is allowed by a decision of this court to produce whatever results he wishes to produce, that he thinks are lawful results, wouldn't that be the results of this case, Your Honor? We are talking here exactly the same thing that Mr. Jeremy said are important for the jurisdiction of this court. We are talking about the same thing, results of the case. The CEO is talking about the same thing in his submissions, the results of this case, the results of the election. And therefore, we don't have a difference of opinion as to the nature of the case. The P3 and Sycamore Singh remain good law, and that has been upheld by Your Honor in the Ulita Moore case, very extensive and detailed decision. And Your Honor utilized Article 140 in conjunction, Section 140, in conjunction with P3 and Sycamore Singh, and has come to a conclusion in that case, which was reviewed by the Court of Appeal and approved implicitly, at least. So there is no issue before no new issue before Your Honor which requires determination. Your Honor, the matters which have been, which I have raised in my submissions, have also been raised in the other submissions before you and have been extensively dealt with. And of course, I don't wish to go over those matters, but merely to say that the attempt to eliminate, or the attempt to eliminate the discretion of the Elections Commission to determine the results of these elections takes us back to a time prior to 2000 that we do not wish to go. And I would urge Your Honor to uphold the decision you made in the Ulita Moore case with different facts and circumstances, not too different, but different issues raised here, and to maintain the power of the Elections Commission under Article 162 to make such decisions to sustain impartiality and compliance with laws, and to maintain the constitutionality of Section 22, and allow the Elections Commission to complete the task of making the declaration they're supposed to make. Thank you.
Thank you very much. Mr. Jonas?
Thank you very much, Your Honor. So to your instructions, I have tried to distill, after having heard submissions, what remains. I believe that two narrow issues are left, and I would like to address them, but I will intersperse them, with your permission, with the discussion of the issue of res judicata. I heard it said that we've already dealt with the issues of whether Section 22 is constitutional, and the fact that that should be left for an elections petition. And we've already addressed the question that the Moore case deals with the recount, but I heard it sought to be distinguished that Moore's case predated the Order 60, which is now impugned. I'm sorry, Your Honor, are you hearing me?
Yes, I'm hearing you.
Your Honor, may I just ask a question, please?
Yes.
Am I next in the button order?
No, Mr. Datadin is next.
And am I next after Mr. Datadin?
Yes, that's so.
Okay.
Yes, go ahead, Mr. Jonas.
Thank you very much, Your Honor. So the contention was that Moore's case can be distinguished because it predated Order 60. That is without doubt, but I don't think that that puts the other side out of the woods. I'd like to refer you, please, to what is raised, the issues that are raised in the Moore's case. It's in paragraph 38. It is that GECOM and its officials have no authority to undertake a recount, that because the returning officers have filed their reports, the Representation of the People's Act is triggered automatically so that the step-by-step process takes place, and GECOM, without any thought, like a robot, must follow those step-by-step procedures, accepting as gospel every document received by its officials. Now, of course, that has already been disproved, but insofar as it was dealt with by the Moore case at paragraph 85, the Court of Appeal in Moore was clear that the decision by GECOM whether or not to conduct a recount is GECOM's decision, and any challenge to that is the subject of an elections petition. Now, Your Honor, I respectfully contend that that becomes res judicata. When GECOM decides in the conduct of an election to conduct a recount, the Court of Appeal has already said, and with great respect, you're bound, but in any event, as a larger concept, the decision to conduct a recount has to go to an elections commission. That concept is res judicata. And at paragraph 88, please, in rejecting the contention that there is an automatic progression of the act, so that when you get your statements from your returning officers, the CEO prepares his report and GECOM must automatically act on it without looking behind it, even if it knows something is wrong. That is also rejected in paragraph 88. And GECOM's response to those documents also, if questioned, must be questioned in the form of an election petition. So again, that question of law would become res judicata. Now, the reason that I say the distinction which has been sought to be drawn in Moore, that it predated the order and therefore a new issue arises in this case, does not hold water, is that that very order which is now sought to be impugned was specifically addressed by the Caribbean Court of Justice in the Eslin David case. And if I can refer you, please, paragraph 5 of the CCJ decision specifically points to the order 60 and says that GECOM ultimately decided to recount the votes cast. It issued an order. Now, Your Honor, a lot has been made of whether Section 22 is unconstitutional, again, for an elections petition, whether GECOM has power to pass or to conduct the recount, again, res judicata already decided. But I would like to make the point, please, that in my respectful view, the fact that GECOM under Article 162 can supervise and ensure transparency, ensure fairness, and the fact that as a tribunal, GECOM has a duty, if it knows from its own body of record that there has been some fraud, some error, some miscalculation within its body. We don't know, but if GECOM has that obligation, if it knows within the ambit of its records there is a problem, it acts unlawfully if it proceeds notwithstanding that problem. And the authorities in my written submissions bear that out, please, Your Honor. A tribunal who has knowledge of an internal illegality cannot close its eyes and blinker itself and move ahead as Your Honor is trying to be persuaded. The tribunal will act unlawfully if it does so. It has to fix it. And GECOM has fixed it by the recount. Because GECOM is entitled to fix it and has decided to do a recount, questions of unconstitutionality of Section 22, questions of whether Order 60 was lawfully gazetted and that kind of thing, are not germane to the reality that what we are talking about is a lawful recount, a recount lawfully conducted, and which may only be challenged by an election petition. Because it is the recount that is the res. It is the recount that we're talking about, not pieces of paper. GECOM 200 years ago could have sent town criers around to shout from every corner, we're going to do a recount. Or they could have put it on their website. They chose to publish something in the Gazette for everyone to see. But that does not vitiate the legality of a recount determined by them to be done and approved by the Court of Appeal in the Moore case by which we are bound. But even if the Moore case did not address the legality of Order 60, the Caribbean Court of Justice very specifically did. In paragraph 6, the CCJ discussed what was intended with specific reference to Order 60. And I was bemused when I heard the artificial distinction which was sought to be drawn before Your Honor, that although you can have a recount, you can't act on the recount. That astonished me, because what is then being said is that Your Honor must overrule more, where the court said you can do a recount, and if you don't like the recount, go to an elections commission. Go to an elections petition. What that argument says, that if you do your recount, you can't act on the figures, even if those figures show fraud or miscalculation in your first count. That leads us into the ridiculous. But it is specifically rejected by the Caribbean Court in the Eslin Davis case. And at paragraph 6, the last sentence of that paragraph, the CCJ reminds us that paragraph 14 of that Order 60 provided for the Commission to make a declaration on the results of the final credible count of the elections. The CCJ has specifically reviewed and approved not just the recount, but the contemplation that the result of the recount will be binding and will be acted upon. And therefore, any argument that somehow this recount can't be used by GECOM is specifically rejected by a court which binds us. Now, again, Your Honor, following on that, the argument is presented that the chairman, that GECOM, through the chairman, cannot tell Mr. Lowenfield how to present his report, on what basis to present his report. But again, the CCJ has specifically refuted that. At paragraph 8, the CCJ says in its final sentence in that paragraph, with approval, by letter of 16th June, the chairperson issued the following directive to the CEO, pursuant to Article 177(2)(b. Is Your Honor hearing me?
They're fine. Yes, I'm hearing you.
Sorry.
I'm
Thank you
following
very much. And Section 96 of the Representation of the People's Act, you are requested to prepare and submit your report using the results of the recount for consideration by the Commission. So before the CCJ, we've moved past more. And what is now res judicata is the approval of the methodology which is set out in Order 60. The decision that you can use the recount figures that are established by the recount methodology of Order 60 and the direction to the CEO by GECOM through the chair to use those recount figures in his report. Now, Your Honor, can I take you to paragraph 14, I'm sorry, of the decision of the CCJ, which speaks to the issues raised by Ms. David and the objections which she took to what GECOM was doing. Ms. Davis quarrels that Order 60 ushers in some amendment, a new and legally different regime, that GECOM abdicates its responsibility, and that the same letter of the 16th of June requires the CEO to commit an illegality. So those are specifically the questions which are raised in the Desmond David matter, which are addressed by the court in that matter, and which are now sought to be raised before you again. I heard Mr. Williams argue before Your Honor, and again I was surprised, that if the CEO submits his report, that's the end of the matter. Everyone is bound. GECOM has to follow that report. Your Honor, again, that would be an astonishing result. It would mean we could throw away everything else and just wait for Mr. Lowenfield to submit what he wants. But again, that argument has been specifically rejected by the CCJ, by whom we are bound, and which now becomes res judicata. At paragraph 17 of that decision. CCJ points out that ignoring the instructions, ignoring the letter from GECOM dated 16th June, the CEO took it on himself to invalidate votes that he considered ought to be invalidated. His new report invalidated over 100,000 votes that had previously been counted and certified. And at paragraph 47, the Caribbean Court of Justice says the idea that the CEO or GECOM could, in an unaccountable and non-transparent and arbitrary manner, without due processes and the legal standards established in Article 163, disenfranchise scores of thousands of electors is inconsistent. And as Your Honor knows, the CCJ specifically set aside as void what Mr. Lowenfield tried to do in his report. It is therefore surprising that Mr. Williams can argue with a straight face that this new report that Mr. Lowenfield has now submitted, which again bears no resemblance to any of the numbers which are presented to him, even Mr. Mingo's original fraudulent numbers, it doesn't match those. Somehow, Mr. Williams argues with a straight face that GECOM can't look behind that, we're all bound by that. But the CCJ specifically says that Mr. Lowenfield cannot go on a frolic. And the authorities clearly show that when Mr. Lowenfield goes on a frolic, as he has done again, and GECOM is aware of it, because GECOM has received Exhibit BJ4 to borrow Jack Deo's affidavit, GECOM has received from the same Mr. Lowenfield the recount numbers as per the recount done at the conference center. So when GECOM receives that report, knowing it bears no resemblance to any numbers and certainly bears no resemblance to the recount numbers that they have lawfully directed Mr. Lowenfield to use, certainly a court would set aside what Lowenfield did. But equally certainly, GECOM cannot unlawfully blinker itself to that huge disparity and blindly accept the numbers provided by Mr. Lowenfield so as to change the result of the election, which is what the applicant is asking Your Honor to rule. So each of the objections which are raised, each of them are specifically addressed by a decision which I must say with great respect to the CCJ, I have read over and over with increasing admiration, because each of them is addressed specifically. Now, Your Honor.
Mr. Jonah?
Yes, please.
Time is as good as up.
I was hoping to deal with the issue of res judicata, Your Honor. I wonder if I could have 2 minutes to do so.
You have mentioned res judicata on many occasions whilst you have been making your submissions, and I do appreciate the concept. I did ask the question in the issues that I put for consideration in the submissions. And I think Mr. Ramkaran, I should say Kamal Ramkaran, went through some of the issues.
I just had hoped, Your Honor, in my written submissions, I had pointed out that the tenor of certain proceedings which enable members of the public to be informed and to come on board are more prone to be treated as judgments in rem, so as to found res judicata. For example, the land court matters where you gazette a claim for prescriptive rights. The whole world knows and can come on board. Is specifically contemplated by our Judicial Review Act and by the procedure set out in CPR 56. Thank you very much, Your Honor.
Okay, I did read that in your submissions, and I noted because and I think it was you who mentioned Halsbury's.
Yes, please, Your Honor.
Exactly, because I also read the Halsbury's 5th edition, which has learning on this issue also. Well, just update. Because the case is this, cases have some vintage. All right. Good, thank you very much. We will now go to Mr. Dattadin.
Good evening, Your Honor.
Good evening, Dattadin.
In an effort to avoid what has been covered before, Your Honor, as it relates to jurisdiction, for the record, and as per our submissions, we are of the view that the court has no jurisdiction because of Article 163, because of Section 140 of ROPA, and the dicta in Petrie and Sikumar. Those have been gone through. But Your Honor, we wish to add something that was raised by the applicant as relates to obiter and Section 22 of the Elections Law Act. Your Honor, it is our contention that Section 22 was not dealt with obiter in the Yulita Moore case. That we don't agree with that. But Your Honor, even if it were obiter, because it was a specific determination on a specific issue by the Court of Appeal, which is higher in the hierarchy than this court, it would be very unusual for this court to disregard it. And of course, what that court decided, Your Honor, was that Section 22 was indeed constitutional. Your Honor, I didn't include the authority in my submissions because that issue had not arisen until today, but the authority for the record, and I'll send one to the court, it's Ying versus Song, S-O-N-G, 2009, New South Wales Supreme Court at page 1344. So obiter should only be departed with in exceptional circumstances in the hierarchy if the court has specifically addressed the issue. Your Honor, now to if we could just move, the second issue would be as it relates to the general principles as relate to res judicata. Your Honor, that has been traversed at length, that it must be the same parties, the same litigants. But Your Honor, we have to address it frontally with great respect. We have to address frontally what this is. Even Mr. Edwards, for the Honorable Attorney General, Your Honor, said that what had been addressed in David and what was the subject of these proceedings is Article 177(2). So the Attorney General recognizes that. The submissions of the applicant similarly recognizes that. So, Your Honor, if, without belaboring the point, Your Honor, if you look at XX1V24 in the grounds of the application before you, what is contended is that an instruction was received on the 9th, 10th, and 13th of July 2020, the CEO, and the instruction violates the principle that the CEO should act independently in compiling his Section 96 report. Your Honor, that continues with XXV, which is 25, 26, 27, make mention, those ones make mention that Order 60 of 2020 was declared invalid by the Caribbean Court of Justice, which is factually inaccurate. It was not declared to be invalid. But Your Honor, if we are to take it frontally, the crux of the issue is the Chief Elections Officer adopts the attitude and believes and is pursuing that under Article 177, he is entitled to an independent or an absolute discretion. The substance of the litigation have all been, both of them, David and these proceedings, are identical. Your Honor, what is being questioned, and it's unique in these proceedings, as it was in David, that the litigant, the applicant, could not bring the evidence to this court. Now, firstly, Your Honor, Section 140 of ROPA would not allow whatever happens from the commission to be allowed into the court, save and except in an elections petition. But the evidence, the court has expressed a view about the affidavit filed and the facts contained therein. But Your Honor, without the evidence from the CEO, the third respondent, that he is being instructed to do things pursuant by the Commission pursuant to Section 18 and pursuant to 162 of the Constitution, and he is not being allowed to do that. And his affidavit, he in fact attempts to demonstrate why the decision that he is being asked to follow, he should not follow. But Your Honor, that is the crux of the case. Without his affidavit, there is no evidence from this litigant before the court upon which the court can act. Ms. Jones, it would be all hearsay. But in any event, Your Honor, if we come back to the issue of res judicata, it is true that this is public interest litigation, or what is commonly termed public interest litigation, meaning every citizen brings it for the interest of the public. And any citizen can in fact bring it. But it would be an abuse, please, Your Honor, if every citizen were to bring the identical issues against the same public body over and over. With great respect, Your Honor, that is essentially what has happened in David and what is happening now. And if we are to take it to its logical conclusion, Your Honor, in David, the CCJ was clear. Paragraph 45 of the judgment, I wouldn't read it for the court. It's been read half a dozen times, but it has been expressed that the validity of the votes has already been decided by GECOM, and the only thing that can change that now is an election court hearing an election petition. Now, Your Honor, that would mean that the CEO, the third respondent here, the Chief Elections Officer, he's mistaken, respectfully, Your Honor, when he believes that where the Constitution says it's on his advice, it is a unique, independent advice without any direction or control from any authority. And respectfully, I say to Your Honor that if the court is to address that issue and to say, for example, if the court finds favor with what I'm saying to the third respondent, that you do not have this independent discretion that you're operating as if you do, and you believe you do. And Your Honor, if we're to go back just a little bit more as to the jurisdiction and res judicata, Ms. Jones might not have been a party to those proceedings, but certainly the Chief Elections Officer has been a party to all. But he, in one proceeding that was before the court in Moore, he took no active part, quote unquote, but he was still a party to the proceedings. So the determination in David by the Caribbean Court of Justice binds him. He was a party. But in these proceedings, Jones, he proffers to the court, he offers evidence dependent on what the court is going to take of the view. And I fully understand the court's view and the likely outcome of where that goes. But Your Honor, what has happened is he's bound by what he should do. He has preferred the position where he will introduce to the court evidence of matters where he is saying that he's been instructed to do things which are not within the law. But Your Honor, Section 18 is very clear. He is under the direction and control of the Commission. And Article 162 of the Constitution is similarly clear. The Commission has the power to direct any of its officials to do that which it should do. But Your Honor, it flies in the face of res judicata, and my friend Mr. Ramkaran Younger, Kamal Ramkaran, dealt with the issue as to why it would be an issue. But it certainly is an issue, and that can't be disputed. And it also can't be disputed that the Chief Elections Officer is involved in all of the proceedings that have come to the court. And the Chief Elections Officer is fully aware, with respect, Your Honor, as to what he's been instructed to do and what the court has directed that he do. Now, I don't wish to belabor the point, except to say this. If, for example, in these proceedings, we are to take the utterances in the affidavits and what is contended in the affidavit or in the grounds, for example, that the chairman of GECOM wrote a letter on X date, that letter instructed the third respondent to produce a report in accordance with the recount data. Then we go on from that, Your Honor, that he was again written on the 10th, essentially the same thing, that he was written again. So they narrate this. They then say such an instruction is not only violates the principle that the chief elections officer should act independently in compiling his Section 96 report, but it's a direct conflict with the decision in the Caribbean Court of Justice. Now, the latter part is simply not true, and the earlier part, that it conflicts with the statute, is respectfully, Your Honor, also not true. He does not have an independent and absolute discretion to give advice. He can't give advice on how to fly a plane or drive a car. He has to give advice that is based on a recount of numbers of votes. Now, as the Caribbean Court of Justice was at pains to say about the validity of votes, it was a seemingly arbitrary and not transparent way by which the CEO essentially removed initially 235,000 odd votes, and we don't know where those went. And then he, on the next declaration he removed 115,000 votes. We don't know where those went. But strangely enough, Your Honor, the last declaration, he added 14,000 votes. Your Honor, this is not a game. This is a country's democracy. This is the will of the people. The CEO doesn't have these absolute rights that he mistakenly believes he does. And he ought not be allowed to support litigation brought by purportedly I take that back, not straw, by public-spirited citizens who are bringing proceedings in the public interest, and he is in fact the supporter. Because, Your Honor, that flies in the face of how we will conduct ourselves. Because then we would mean that we would have all of the individuals believing that they are entitled to so do. But they're not, respectfully, Your Honor. And since it may be difficult for the court to go and tell 217,000 people that you cannot all come one at a time to file these proceedings, the court, we beg, Your Honor, would make a direction or an order, a suitable one, that the chief elections officer's role is circumscribed by what is written in the statute and what is written in the Constitution, and that what he believes to be a free discretion that is absolute for all is not in fact so. He is a statutory officer who must do his job. Your Honor.
Mr. Datadin, I think you belabored that point.
Yes,
do you have any other quick point? We have to go to Mr. Jeremy.
Moving on, just quickly, Your Honor. As it relates, Your Honor, to one of the questions posed by the court, which was, and I wrote it, so I'll take my handwritten note about it, is whether in fact the returning officer's declaration would set aside the declaration or the numbers that came out of the count under the statutory regime. Your Honor, it's whether the recount numbers will take the place of whatever was there before.
But you said it the other way around.
As I said, Your Honor, these were not your words, they were mine. So forgive me. But Your Honor, I say this. The recount was not conducted, and much is made in this application about the recount having been conducted and there was no returning officer, etc., etc. Your Honor, when there was a refusal of the counting agents of the various political parties, when there was a refusal by the returning officer for a recount to take place, Your Honor, the recount that took place outside of the established statutory regime. It took place by an order which GECOM felt, and GECOM respectfully, Your Honor, was entitled to make pursuant to Section 22 and Article 162, 1B of the Constitution, which, Your Honor, surprise, surprise, is what GECOM in fact says. Those were the two pieces of legislation they were relying upon to formulate Order 60. Order 60 has been addressed by the Caribbean Court of Justice and said it was a carefully crafted document to facilitate and allow a recount to take place within the confines of the dispute and the legislation that was in existence. Your Honor, that's what happened. The recount, as my friend Mr. Jonas says, laid bare for all to see that there was something wrong with the numbers that existed.
Mr. Dattadin,
Yes,
you are rehashing information that is common knowledge, has been spoken to before.
Your Honor, I'll go on to it.
So do you have any other different point to add?
Your Honor, as a result of the recount order, GECOM, which is the first respondent, the commission was entitled, as it did 2 days ago, to say that the previous numbers that were held in abeyance are declared to be no longer applicable. Your Honor, unless I can help Your Honor with anything else.
No, thank you very much.
Thank you very much, Your Honor.
Yes, Mr. Jeremy, go right ahead, please. You are in reply.
Thank you, Your Honor. Your Honor, how long do I have?
Well, I have 20 minutes, so it's 6:45, and so yes.
Okay, thank you.
And I received the reply submission, so
yes,
they're not very long, so that's very good.
I rely on them, but of course I did not anticipate the day-long submissions from the multiple parties today. I'll be brief as I possibly can. Your Honor, in respect, I'll just take it point by point to attempt to truncate this process. In answer to the proposition that this court's jurisdiction is ousted by Section 140, we see that Section 140 is pronounced on by Ulita Moore. And I think that is common ground. And that the Ulita Moore decision is quite clear that 140 at the bottom of the page is
which paragraph are you referring to in Moore, so I can pick it up?
108.
Paragraph 108, yes, very well.
We referred to several times. What it does is on the main issue in this appeal, we have found that the jurisdiction of the High Court can be exercised to grant relief during the election petition process in spite of Section 140. That's it. That's the starting point. So we say we have jurisdiction. You have jurisdiction. That jurisdiction can be exercised where the court is satisfied that GECOM has acted or is about to act in excess of its constitutional and or statutory powers. We say this is one such case. That we have satisfied Your Honor that GECOM has exercised or is about to exercise an act which is in excess of its constitutional and or statutory powers. Now, I say that because in embarking on the Order 60 exercise, GECOM is going beyond the Constitution and the law. It is embarking on what the attorney for the chairperson said, and I might have got the words wrong, was an unintentional trespass on the jurisdiction of the High Court.
She didn't say unintentional trespass. She was saying, and I have the notes here because I did question her about that. Excuse me, just let me find it. Okay.
Your Honor, she didn't intend.
She didn't say unintentional. That it was never the intent. GECOM never intended to trespass on the Article 163 requirements, and that was never the intention of Order 60. So that's when I engaged her that the question, what you might not have intended, you might not have intended something, but it might still happen.
Right. So I'm just about to go on to that because they went on to open ballot boxes and so on and so forth, which is quintessentially a matter for an election petition filed in accordance with the law. But they did that. The evidence is there. It's uncontradicted. Now, in respect of my little friend Mr. Mendez's suggestion that Section 18, in respect of and I'm just jumping around to try to finish on time. Section 18, in respect of the Election Laws Act, purports to give power to the chair. That purported exercise of power. I want to say two things about that. One, it's in conflict. Section 18 is in conflict with Section 177(2) of the Constitution, which expressly provides, and I've heard the Attorney General give an interesting history for one who is not Guyanese as to precisely why this section was enacted. The people of Guyana have a right to their constitution. They have a right to ensure that they might be small, but they have a right to ensure that their constitution is not trampled on by countries large, small, and in between. The Constitution expressly provides that it is the chief election officer who gives advice to the chairman, and whose, after such advice has been tendered to the Elections Commission at a duly summoned meeting. And the presidential candidate, the CCJ's decision is quite clear. They are Siamese twins. You cannot separate the one from the other. The election of the president is the same as the election, the general election. Presidential candidate shall be deemed to be elected as president and shall be so declared by the chairman of the Elections Commission, acting only in accordance with the advice of the chief elections officer. Those words are clear. So I say for two reasons, that article in the Constitution is in direct conflict with Section 18 of the Election Laws Act. But the question is, what do you do? The Constitution, and I say there are two reasons why you have to give effect to the Constitution. One, it is a supreme law, and two, the words in Article 18 are general in nature, and they are typical words that you find in relation to every commission, which says that the officer is subject to the direction and control of the commission. Those are general words.
Mr. Jeremy, what about Article 162, which also speaks to the general control of the commission over its staff, etc.?
Yes, again, Your Honor, they are general rules, so that they cannot trump the express provision which is provided by the Guyanese people in the Guyanese constitution for what happens in the event of a dispute between the chief elections officer and the chairman of and the chairman. It is not the other way around. The chief elections officer, the constitution is clear and admits of no other meaning. Your Honor, on the question of the Article 162, which you referred to just a second ago, and the contention there was, why can't the order be made under Article 162 instead of Section 22? Well, there are two reasons. The 162.2, I'm sorry, 161B. Oh, I'm sorry. It's late in the evening and my eyes are not what they used to be 10 years ago. The elections 162 says the Elections Commission shall have such functions connected with or relating to the registration of electors, the conduct of elections as are conferred upon it by or under this Constitution or subject thereto, any act of Parliament, and subject to the provisions of this Constitution, the Commission shall do a number of things. Nowhere in their 162 is there any license on the Elections Commission to do anything in respect of the promulgation of an order. And if you turn the page, so this is 162.2. As matters that the Election Commission may do, it says the Constitution provides, notwithstanding anything to the contrary in the Constitution. If the Election Commission is satisfied that the holding of an election pursuant to provisions of so and so not to be done, it may do two things: postpone the holding of the election to the specified, postpone the voting in any area specified in the notice that they were specified. Your Honor, if there was any enabling provision in 162, it would have had to see that it was an enabling provision. That is basic law. And as much as we might not like the consequence, my learned friends might not like the consequence that they are being driven to, this is what the Constitution and the laws of Guyana provides. And they must respect the law of Guyana. So my junior is pointing out to me that because 162 is subject to the Constitution, no steps can be taken by the Election Commission that contravenes the provisions of the very next section, which is section 163. That is the section which deals with the election petition section. So you have a declaration of a result, and what you need to do thereafter within the time, you might not like the declaration of the result, Every loser does not like it. And I've been sitting here listening to Mr. Mendez giving evidence from the bar table about how many votes he got, and listening to him talk yesterday about bowling from wherever, as if this was a cricket match. It's not a cricket match. The future of the people of Guyana is at issue. This is serious business.
Mr. Jeremy, please focus on the law. That's what I've been trying to have all counsel do. I've been saying ad nauseum, I am not interested in how many votes have been counted and all of those issues. Let's just stick to.
And so are we, Your
Thank
Honor.
you very much.
I've been heartened by
So
your.
You've made some points in relation to legal issues so far. Ms. Kite's intervention on the intention to stress person 163, Mr. Mendez's submissions in relation to section 18, and you've just been mentioning article 162.
Yes.
Is there anything you would like to say on the res judicata points that have been raised, especially by the last few
I'll be very brief on that because I think that the law is clear. Your Honor, may I?
Yes, go right ahead.
Okay. I think that the law is quite clear on it. My little friends have tried to suggest that we are not the same party. I'm sorry, we are the same party, that the issues are the same. These are new facts. Before this matter, there was no dispute between the chairperson of GECOM and the CEO. That is what has prompted this action. Of course, the three conditions which are required to be set out by the CCJ in the Garaway case must be set out before you look at the consequences of res judicata, which is issue estoppel and all of those things. Those consequences, those conditions are not met on these facts. Your Honor, much has been made of the fact that the CCJ spoke in laudatory terms, undoubted, of the process of transparency and of the order and so on. The point is that at paragraph 15, sorry, at paragraph 41, it says that, I'm sorry, Your Honor, my eyes again. At paragraph 40, the court says that the exclusive jurisdiction of the High Court through Article 163 to determine among matters any question in relation to whether an election has been lawfully conducted or the results affected by any lawful act or omission was naturally unaffected by Order 60. That article is constitutional in character.
Mr. Chairman, please do not read out the whole paragraph. Thank you very much. I have it.
So, Your Honor, those are the submissions in reply to the applicant.
But I'm not understanding your quotation of paragraph 40, though, I must confess, because you said much that the CCJ has spoken in laudatory terms in relation to transparency in the order. But in paragraph 40, well, I'm trying to understand, what are you saying in paragraph 40 really?
Well, I'm saying that if you speak in laudatory terms about the objectives of an order, but then at the end of the day, you have paragraph 40, which forms the ratio of the decision, and then on top of that, you have paragraph 52, And I'm not reading it out, but at the very end, the notion that Order 60 could either impact interpretation of the Constitution or create a new election regime at variance with the plain words of the Constitution is constitutionally unacceptable. So, yes, transparency is something that we all wish. Yes, transparency is something that we all wish. But the fact is that the order has not been affirmed by the decision of the CCG. What you find in paragraphs 50, just make sure that my junior is reading to me, paragraph 52 and paragraph 40 is that the CCJ have denied effect to the validity of the order. And
They
so
have, sorry, they have what? Sorry?
they have denied
They have denied effect.
to the validity of the order, at least the effect that GECOM wishes to place on it. Those are the submissions in reply, Your Honor.
Good. Thank you very much, everyone. It's been a long day, but I must say I'm still quite refreshed. I could have gone for maybe another hour or so. So it's the level of engagement that I've had all day. It's been quite energizing, I must say. But I had hoped that I would have been able to finish the decision by Sunday. But I think with the richness of the submissions that have been given to me today, I would fix this for Monday. I'm thinking Monday at 4 o'clock in the afternoon.
Therefore, we can live with that.
We'll adjourn to, that's the 20th at 4? Yes.
Very good. Very good.
Grateful, Your Honor.
Much obliged, Your Honor.
Thank you very much and have a good weekend.
Thank you, Your Honor.
Thank you.